Good morning, everybody. We want to welcome everybody to the Thursday, June the 19th, 2014 meeting of the Alarm Systems Contractors Board. Ms. Bess, would you please call the roll?
Scott Coffroff,
Here.
Keith Harvey, Vivian Hickson,
Here.
Karen Jones, Mackenzie Roberts.
Here.
Let the record show that Keith Harvey and Karen Jones are not present, but you do have a quorum, Madam Chair.
Thank you. Have the board members had an opportunity to review the agenda that's presented for today's meeting, and if so, a motion to adopt?
Make a motion to adopt the agenda as it's been presented. Second the motion.
Okay. We have a motion and a second to adopt today's agenda. All in favor, voice by saying aye.
Aye.
All opposed? The motion is carried. Has the present board members had an opportunity to review the minutes from the March the 27th, 2014 board meeting? And if so, a motion to approve.
Madam Chairman, I have, and I make a motion that we approve the minutes as they have been presented.
Okay, I'll second it. All in favor, voice by saying aye.
Aye.
All opposed? The motion is approved on the minutes. Do we want to move forward with the election of officers with 3 here, or?
That's what I was going to ask. We do have 2 members missing, not present, excuse me, and 1 new board member. So if you would like, we could postpone to our next board meeting if you'd like to do that. What is the
I make a
consensus?
motion we postpone the election of our officers till the next regularly scheduled board meeting. I second that.
Okay. We have a motion and a second to postpone the election of officers until the September 2014 meeting. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Madam Chair, I'd like to take a moment before we go to the next item of the presentation, and I would like to thank Steve Tucker for his participation on the board for the years that he has served, and we certainly appreciate everything that he's done for us and the time that he served. And we'd like to welcome Mr. Scott Cockroft, pronouncing that correctly, as our newest board member in the place of Mr. Tucker. So thank you.
We do welcome you, and we are going to miss Mr. Tucker. He was always had some interesting comments, so you'll have to fill his shoes.
We expect a lot from you, sir.
That's correct. Okay. Are we ready for the presentation on the Tennessee Open Meetings Act?
I don't know. I think a couple of you know me, Mr. Cockroft. Likely doesn't. I'm the chief counsel here for regulatory boards with Commerce and Insurance, and I'm introducing Mr. Damon Romano. Mr. Romano joined regulatory boards last summer after his second year in the inaugural class of the Belmont University Law School. He's been with us since that time, and more recently he moved up into a full-time position while studying for the bar as a paralegal with the general civil side. He put together this presentation. It's been going around to all the boards and commissions. I believe this is, in fact, the final board that we have to give the presentation to, so we did save the best for last. Without further ado, I will turn it over to Mr. Romano.
Folks, thank you for having me this morning, and thank you for taking some time out of your agenda. I mentioned this is a presentation that is that on these sunshine laws, and a lot of our newer members have never heard this stuff presented in a formal kind of instructional format. For those that are very long serving, they maybe haven't heard it in 5 or 6 years. Board members and commissioners, some cobwebs have kind of accumulated, some misconceptions have grown up, and there have been some changes in the law that a lot of people have not had an opportunity to become aware of. And so that's why I'm here this morning, excuse me, to talk to you about these sunshine laws, to give you kind of an overview, predominantly in terms of what's expected of you all as board members, as commissioners, and then is that as we move forward, all of the boards and commissions in the larger division of regulatory boards can all be on the same page moving forward in lockstep, as it were. So when we talk about the Sunshine Law, we're really talking about two different laws. We're talking about the Open Records Act, and we're talking about the Public Meetings Act. I'm not going to spend a lot of time this morning on open records as a matter of day-to-day conducting of business. That's something that your executive director, Ms. Vest, and her capable staff deal with. It's going to pick up things like Freedom of Information Act requests, public records requests, things of that nature. If you have any further questions about that, she would be your best go-to person, or you can all. Briefly, we'll talk about it. What's included in open records? In other words, what are you responsible for keeping? And then once kept or once recorded, who can ask for it? And the answer is the public, which is pretty much anybody can ask for it. What do they get, or what can they ask for? The law tells us all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, or if that's not enough, other material regardless of physical form. So what's included? Everything. Now, it doesn't mean that everything is what we're going to give out to the person making the request. There are certain exceptions in the law that say that there's some sensitive information about our licensees, but everything is subject to request. And that's it. That's all we're going to say about that this morning. As I said, that's something that Ms. Vest deals with on a day-to-day basis. And so we'll move on to the crux of it. For our purposes this morning, the Public Meetings Act. We'll talk about what the Meetings Act is, what is a meeting, and what's not a meeting for legal purposes. What's required of you all? Broadly, that's going to be the notice, the agenda, public presence, minutes. We'll discover as we go on that once we deal with what a meeting is and what it's not, and what notice is, we will have covered about 95% of it in terms of what you all need to know in conducting your daily affairs. And then what if you violate the Sunshine Law? What if you take some decision off the record in a way that violates the law? Simply the penalty is going to be nullity. And what that means in plain English is that if you get sued over it, the court is going to rewind the clock back to the point at which the violating decision was made and start from there, as though it never happened. And it doesn't sound that bad, but we'll see as we go on, it could potentially have some fairly disastrous consequences. So let's dig into the law a little bit, and let me pause here, folks, real quick to say, as Michael just told you, I am a recent law graduate. I have learned over the last 3 years to loathe and despise legalese. So I'm going to not try to use that on you. There is some law that we have to go through, and there are just two law cases that I will tell you the story about later as we go on. All right. Here's our general rule that's our foundation for everything. The General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business and shall not be conducted in secret. Public policy, as far as you're concerned, is largely going to be your rules, your regulations. Anytime you adopt a new rule, amend an existing rule, delete an old one, that's public policy. Decisions, pretty much everything else. Issuance, revocation, suspension of licenses, discipline against a license's civil penalty. Decision to elect new officers, that falls under that heading as well. Shall not, this is the free speech clause of the Tennessee State Constitution. And what they're telling you is that you don't give up your right to free speech as a citizen of the state just by volunteering to serve on this board. What it is telling you is that whatever you choose to say, you need to understand is going to be part of the record. Some small aspect of your privacy when you volunteer to serve in this capacity as a member. All right. The act is remedial in nature, which is a fancy way of saying, folks, we can't fix a problem until after it arises. And so it's going to be construed very broadly by the courts and by the legislature too, to promote openness and accountability in government and to protect the public against closed-door meetings at every stage. And this is the beginning. You're going to see here that every time, without exception, the legislature or the courts mentions this issue, always do so in this very broad, very expansive language, intending to leave no loopholes at all. Again, all meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution. That except down there refers to what's called the executive sessions. We'll talk about executive sessions in a few minutes. The act applies to this board, all of the boards and commissions in the division. It applies to governing bodies. A governing body is a member, the members of any public body which has 2 or more members with the authority to make decisions. Hang on. It applies to governing bodies, but then we say, well, a governing body is just a kind of public body or part of a public body. Then haven't we just moved the problem back one step? What then is a public body, and does that apply to us? What they mean to pick up here are your committees and subcommittees. Anybody that's authorized to make decisions. So you have had a problem in the past where you haven't. We have had a problem in the past where you'll have. Understand that everything we do in these full meetings of the whole commission, everything has to be on the record under the gavel, properly recorded and noticed and so on. But we can go into our secret room behind closed doors off the record at committee and subcommittee meetings. No, that's what this is telling you there. We're going to pick up those committee and subcommittee meetings. Also need to be properly noticed and on the record. Meeting means the convening of a governing body, of a public body, for which a quorum is required. Excuse me. Which would be your subcommittees and committees as well, in order for the. All right, what's not a meeting? There are, the question has come up in the past, hang on, we've got they swing too far the other way and they get paranoid. And they think everything is a meeting. And then they are almost too paralyzed to act. So we're going to try and put some fences around it and some bounds around it. Meeting does not include, for example, any on-site inspection of any project or program. I confess, Madam Chair, that I am not entirely familiar with how alarm system contractors work. I'll give you an example from Motor Vehicle Commission. Sectors to car dealerships, car lots, to make sure that all of their records are right, their tag law. That's not a meeting of the board that would be required, and you can see how that would. It's not a meeting. This is kind of the crux of it. A meeting does not include a chance meeting of 2 or more members of the public body. However, no such chance meetings or informal assemblages can be used to decide or deliberate public business. Decide or deliberate, there's a third D in there, debate. If you, Madam Chair, and you, Mr. Roberts, run into each other at the Piggly Wiggly and bump shoulders and decide to have a conversation about the weather, your children, grandchildren, whatever it happens to be, fine. But you cannot use that as to say, oh gosh, I accidentally bumped into you at the gas station. While we're here, I have some matter of urgent or pressing board business that I feel like we need to discuss. That's off the books, or that's sort of forbidden at that point. The first case that I wanted to talk to you about there is in the fine print, Aiken versus the town of Kingston Springs. What happened there was, and this brings up that subcommittee thing. You had the city of Kingston Springs, or the town of Kingston Springs, they wanted to annex some of the surrounding land, obviously to improve their tax base. what they did was eventually, when they made the up or down vote as to whether or not to annex, they did that properly noticed to the public on the record, everything was fine. However, prior to that, when they were deciding exact parcels they were going to annex and where the lines and boundaries were, that in secret off the record. And so somebody found themselves annexed and now a citizen of the fine town of Kingston Springs without intending to be and without knowing that they were, and they were upset. And so predictably they sued. And the court said, yes, that was a violation, a clear violation of the Sunshine Law, that they made those substantive decisions out of the public eye. However, they cured that deficiency and they fixed the problem when they took the final up vote on the annexation in the full committee meeting. Like, okay, well, if you fix it after the fact, you can get away with breaking the law then. That, folks, if you get sued, you've already lost. The massive black hole of time, your staff's time, your energy, budget that goes into defending that kind of a suit can really your ability to do your job, at least for that fiscal year. Already lost. It's not a meeting. This is an opinion from the Tennessee Attorney General. Members of the public body can share a meal together at which public business is conducted, but the discussion should not constitute deliberations. Folks, if you can accurately figure out months ahead of time what a judge is going to say as to whether your lunchtime conversation was merely a discussion or rose to the level of deliberation such that it would be a violation of the law, you're smarter than I am. These 3 or 4 Ds, discussion, and then deliberation, debate, and decision. You're not allowed to do those. And so then my caution to you would be that it's something that's best avoided altogether. If you choose to take a lunch recess and choose to eat together, it's not a meeting. Lunch breaks, restroom breaks, smoke breaks, those recesses between, morning and afternoon sessions. If you have a multi-day session, that adjournment overnight and into the next morning, all those are times when commission business should not be discussed. Regular meetings and special meetings count. Also, special meetings are going to pick up their emergency meetings. If you've ever had a situation where our licensees has clearly become a bad actor and public safety is notice that even those emergency meetings need to be scheduled out 2 or 3 weeks ahead of time, again, because they're subject to the Sunshine Law, and therefore you have to give proper notice in terms of letting people know ahead of time so that they can attend the meeting. And that exception is our executive session. So let's talk about that a little bit. You need 3 things to have an executive session, folks. First, it's when one or more of you gets together with Mr. Kilgore, your board attorney, and you are either under suit or somebody has threatened to sue you. And that can be something as simple as you take a break after my talk, or you take a break after the legal report, and you go out into the hall and one of your licensees walks up to you and says, I don't much care for that decision you made on my complaint. I'm going to sue you. That's enough. That meets the threshold or the trigger to where you can now go into an executive session. The idea is for it to be relatively broad. Okay. Mr. Kilgore is your board attorney. You collectively and individually in your capacities as board members are his client. for your ability to meet with him. So, one of you or more than one of you meets with your board attorney, and you're either under suit or been threatened with a suit, and you are there to ask your attorney questions related to that suit or that potential suit. If one of you goes to speak to a high school about the business, or if one of you goes to speak to a trade group, voted permission of the whole board to speak on their behalf at the prior meeting, that might be a problem. It's a problem that's come up in the past. And so you might say, oh gosh, I went out to give this talk and now somebody's upset with me for something I said. What are the legal consequences of that? It's a perfect opportunity to meet with Mr. Kilgore. Cannot do in an executive session is use it as a backdoor to deliberate board business off the record. And part of his job, by the way, is to stop you if you get too far afield. So, scenario goes like this. Somebody threatens to sue you. You say, we need to meet with our lawyer. You pull Mr. Kilgore into an executive session, and you all meet. And you're peppering him with questions and getting his sound legal counsel back in reply. And then one of you says to the other, well, based on what he's just told us, I think we should do X. Stop. It's at that point where you're offering your opinion as to how you might vote if it came up for a vote. And that's where you need to back off, get back into the commission room, get back under the gavel on the record, and continue with your debate there. Excuse me. That's our distinction. How far does this Public Meetings Act go? Some people say, well, gosh, Damon, this is awfully onerous. And it seems like it would destroy our efficiency and our ability to get business done. Here's how far it goes. This is another opinion from the State Attorney General. This was the Maury County Civil Service Commission, and what they were doing was conducting first-level interviews. So the Civil Service Commission conducts job interviews. They meet after the interviews to and then they vet the applicants, and the vetted applicants go onto another list, and the county sheriff's department hires from that list, deputies, support staff, you name it. The State Attorney General says that those meetings after the job interviews are very likely to be subject to the Open Meetings Act. Why? Because you're making decisions about matters that are going to ultimately affect public safety in a very profound way. And so we're going to, of course, say that this falls under the Public Meetings Act. The public has a right to know the decisions that are being made there. So job interviews, yeah, even job, how far it goes. Mention to you electronic communications for a moment. If one of you emails the chair and says, I've come across a news article, for example, or I heard something on the radio that's related to what we do. That's fine. The content of that communication is fine. If one of you goes further and says, that's an important issue to me, I'd like it included on the next agenda. Can we get that on the next agenda? But if you say, here is an article that I found that one of our licensees was, I don't know, arrested last night, and we need to do something about this. Again, stop. That's where you are now offering your opinion as to how you might vote or for debate.
A question.
Sir.
That seemed contradictory to me. You were saying that to send a news article and say, here, we need to do something about that is a decision. On the other hand, that's not what your slide says, because your slide is offering an opinion, not that we should do something, but rather that we should take a specific action, consider revocation.
I can try. Anytime the point is that
saying we should do something, to me, is like saying we should include this on the next agenda.
when Roberts, is for substantive decisions, okay? Like, I want to get X and so on the agenda, that's fine. Taking any action, whether it be revocation or we even need to talk about this person's license in a substantive way, I put revocation on there, but it would be any discipline against the license. That's something they have a right to know what it is you're saying about them. And so we're going to say that that needs to be on. However, and this may be a better answer, later in the slide, but you bring it up now, so I'll get to it now. That gets discovered later. Let's say you get sued over it or somebody makes a public records request. Are they going to see first the content of your communications? Or are they going to see first the fact that you were communicating? So let's say that your communication in and amongst yourselves that hypothetically you had at the Piggly Wiggly the other day. You know, one of you undertakes to or I understood that you all got caught in that horrible ice storm a few months ago. Is there anything we can do? That kind of perfectly innocent, even possibly laudable or charitable communication is something that is going to be seen later. The first thing that people are going to see when they look at that is you've got two members of this board or commission that are talking to each other in an email, on the telephone, over a fax, text message, whatever it happens to be, outside of the context of a properly noticed meeting. And it's going to raise a crosstalk is something that, to the degree possible, ought to be avoided. Folks, I'm not here to bring down the hammer of God on you today, okay? I'm not here to waggle my finger on behalf of the legal department. What I am here to do is let you know that this stuff is out here. These are the kinds of decisions that the courts are making, and these are the kinds of which the state legislature has historically thought about this stuff. And so that as you go forward, choosing to communicate amongst yourselves however you
it would seem like it's a very, very, very fine line there.
Sounds like it's the difference in saying you want it on the agenda and saying why you want it on the agenda.
And that's a good distinction. Yeah, but as I said earlier, even that is kind of, it's a very fine line. And it's easy to have somebody who doesn't know better see it wrongly and come after you for it. And again, you've heard me say, once you get sued, in my opinion, you've already lost. And that's something that you want to avoid. By the way, a workaround for that would be contact Ms. Vest. She's your executive director. You want something put on the agenda, she's there to do it for you, or somebody on her staff. All right. Let's talk about electronic communications then to your board attorney. It's fine to say to him, I have a question about the legal consequences of something the commission has done, or something that I've done in my individual capacity as a board member. But if you've taken an action that is a personal action, and that slide may not be the clearest, if you've taken an action that's a personal action and you just happen to be a commissioner, then that's so for example, if you go to speak to that trade group without the approval of the rest of the board, that would be an appropriate question for him. If you're driving home from this meeting and you get picked up for your 19th DUI in 15 days, that's probably not a question for him, and at that point, you need to seek your own lawyer. This is kind of what I was trying to get at before, Mr. Roberts. There is again, one of those fine distinctions between your communication as a board member with the chair for procedural matters. I want X and so on the agenda. I want it to be in this order on the agenda. I think we need to have an additional meeting next month instead of waiting till next quarter. That kind of procedural stuff, Robert's rules type of stuff that you would rightly and properly direct to your chair, that's what I was talking about before. And there's some room to maneuver here. Here, we're talking about sort of inter-member crosstalk across the board, and that's where we get into very sketchy territory and very dangerous waters.
You really clarified that when you made the distinction between emailing staff. That's much clearer to me now. Thank you.
Yes, sir. All right. Last thing about this, we talked about, and I don't mean to beat the electronic communications to death, but it bears beating because it's been a source of some frustration, and it's been the source of a lot of boards and commissions ending up in court in past years. I talked before about the idea of a chance meeting. If one or two of you runs into each other in the grocery store or at the gas station, we're going to say that's not a meeting. You just bumped into each other and said hey and made your pleasantries and moved on. Talked about how that was not good fodder for, that was not a good context in which to discuss board business. The courts are going to say if one of you picks up the phone to call the other one or undertakes to write an email, that's not a chance meeting because whoever initiated the phone call or initiated the email did it on purpose. And so there's nothing chance about it, and so you can't get away with that. Even if you don't discuss board or commission business, again, it gives the strong appearance of impropriety and ought to be avoided.
But if you did an email and you did a reply all, then that could be a chance.
Yeah, reply all is the source of late nights for Miss Vest. And so that, yeah, reply all is a dangerous thing to have happen to you when you're going back and forth between yourselves and your staff. If she hits reply all in response to, so you email Miss Vest, she emails you back. What if she accidentally hits the reply all button? Is that potentially a violation of the Sunshine Law? It could be. And as you say, at a minimum, the best case scenario, it's a very fine line and it's something that we want to stay away from if we can. Talk about electronic attendance. You have a quorum here this morning, you have one absent member. What if that member can participate by telephone? And I presume you all have had this done before where we just pipe the person in over the PA and they're on the record because it's going through the computer and whatnot. And that's fine. At that point, we're going to drop back and get away from our consensus votes, our voice votes. All in favor say aye. And you have to drop back to a roll call vote for everything. Why? Again, for the protection of the public. They ought to have the right to know who's voting how. And if all of your smiling, shining faces are here in front of them, then they can see who voted how. If one or more of you is coming in telephonically or electronically, then we drop back to that voice vote again for the record. Excuse me. What if the only way that you can get to a quorum is by getting people in over the telephone? There are a lot of board members who would say, well, then we just can't go forward with the meeting. Quorum means 3 out of the 5 of you in this case being here. Not so. Let's say, for example, that only you, Mr. Cockcroft, and you, Mr. Roberts, were here in person, and that was it. Can we go forward with the meeting? Yes. You get on the record, you pipe somebody in telephonically, and you make what's called a statement of necessity for the record. It's not a formal statement. It need not necessarily be written, but something that you get on the record that says, look, we understand that the rules tell us we've got to have a quorum physically present to go forward with the meeting. We also know that we have a mandate from whoever appointed us to do this business in a timely fashion and to get through the agenda. We're only meeting quarterly now, as you pointed out. We've got to get through this stuff. And so we have a necessity. We've made that statement of necessity. We know that we can go ahead and go forward. And then, again, anybody who comes in behind you and looks at the transcript, looks at the minutes of that meeting can say, wait a minute, they proceeded. They didn't even have a quorum. Oh, I see. They had a necessity. And so you're covered, and it's fine. Then we see this very broad construction. The act is to be construed most favorably to the public. It's all-encompassing, applies to every meeting of a governing body, and that exception there at the bottom would take 30 minutes to explain. It doesn't apply to you, so the act applies. And that brings me to the second case that I wanted to talk to you about. The Shelby County Commission had a long-serving member pass away in office. And this is back to serve out the remainder of that person's term, and then you move on to the regular election. And so what happened was that this gentleman who passed away in office, as I said, had served for a long time and had represented a strongly minority part of the county. And it felt as a matter of moral imperative that they needed to get somebody from that same neighborhood, from that same part of the county, to adequately represent. With a short list, and they eventually narrowed it down to one name, and they called that gentleman on the phone and they said, if we appointed you, would you serve? And he said, I'd be honored. And so you get to the next full meeting of the Shelby County Commission. 19 or 21 commissioners. Has words to the effect of, we offer our condolences to this gentleman's family. He served us for a long time, and so on and so forth. Now it's time for us to appoint his replacement to serve out the remainder of his term. Are there any nominations? One name. Second, yes. Is there any debate? No debate. All in favor say aye. Unanimous, aye. Gentleman comes forward, is sworn in, takes his seat, and begins to serve. And any of us sitting here would say, well, wait a minute, that doesn't pass the smell test. Something's just not right. And so, predictably, the county commission was sued and said, the fix was in on this guy. One candidate, no debate, unanimous vote, no vetting of his qualifications, no talk at all about why he would be a good choice. And so you'll notice there at the bottom that it's the Tennessee Court of Appeals, WS means for the Western section, excuse me. And the court applied that penalty that I talked to you about earlier, nullity. We're going to rewind the clock to the time when the bad decision was made in violation of the Sunshine Law, and we're going to pretend as though it never happened. And you say, okay, it's not that big of a deal. I mean, it's a sad story. It is as though the gentleman was never appointed, and he goes home. Maybe he can be reelected the next time in the regular election. But it goes deeper than that. Because now, every vote of the commission in which he cast the deciding vote, gone. Every committee he chaired, all of those votes, gone. And so what happened was, by the time that, this is the Tennessee Court of Appeals, meaning they had already done that whole dance twice by the time they got up to, went to Chancery Court and then Circuit Court and then the Court of Appeals. It took a while. And so not only was it just this black hole into which they poured their time and energy and budget for the duration of this, we're going to now rewind the clock the business of the county, folks, Shelby County's not a small place, comes to a screeching halt, and then we've got to backtrack every decision in which that gentleman was involved. And stuff in which he did not commit or cast the deciding vote, at a minimum, there's a heavy cloud that now hangs over it. It raises a lot of red flags, or whatever metaphor you choose to use. With the best of intentions, here's the moral of the story. Violation of these laws and being less than very scrupulous about adherence to them can have disastrous consequences for the governance of whatever it is. All right, so we'll lighten up a little bit. The public has a right to attend and observe your meetings, but you don't have to let them talk. The legislature understands that you have an agenda and you have to get through that agenda in a timely manner, and so you may choose to allow the public or your licensees to speak on a matter of some importance. If you say, well, we're about to make a decision, a rule change, adopt a rule change that's going to have profound impact on our licensees, we need to let them comment on it before we move forward. You can do that. But you can put reasonable limits on it too. Look, folks, we've got a busy agenda today. We're only going to have a half an hour or 40 minutes or whatever it is for public comment. Or any given person can only speak for 60 seconds. That's fine. As long as you treat everybody the same, you can do something like that. But you don't have to let them speak at all. They do have to be allowed to participate. Not participate. They do have to be allowed to be present and observe. Why? You're not elected. That's why. If the people of the state elect a governor and they don't like the choices the governor makes, they can vote him out of office and get somebody else. You all have been appointed. The public, if they don't like the decisions you're making, cannot vote you out of office. And so these sunshine laws, and this requirement in particular for public presence, are designed to give the public a neck that they can put their hands around and shake vigorously if they need to. It's the accountability mechanism we have for regulatory bodies. We have a three-pronged test for public notice that I'll go through relatively quickly. Contents, timing, and location. Contents of the notice have to reasonably describe the purpose of the meeting. And it's reasonably described, folks. It is not, you're not bound with heavy chains to it, all right? Some board members or commissioners think that it's carved in stone. It's Charlton Heston standing on top of the papier-mâché mountain with the tablets with your agenda carved into the side of them. It doesn't work that way. And we can see this in the fact that every agenda at the bottom of it has the line item, new business. By definition, nobody can know what that is until it comes up. The idea is that if some member of the public goes onto your website or wherever else it may be published and says, I'm really interested in that issue, that's important to me, that they can show up at that meeting and sometime during the course of that meeting have a reasonable expectation that the thing that they care about is going to be substantively discussed by y'all. Around the agenda, say, well, we're tired after listening to this guy blather on for a half an hour or 40 minutes. We're going to take our break early, so on and so forth. That's fine. Reasonably described. You're not bound to it. Next, timing. If you have the most complete agenda in the world and you publish it 20 minutes before the meeting, what good does that do anybody? And so we're going to say it has to be published sufficiently in advance of the actual meeting in order to give citizens an opportunity to become aware of and to attend. The rule of thumb that the courts have applied in the past, 7 to 10 days. If you publish your agenda 7 to 10 days before the meeting, you're covered. As a matter of fact, your meetings are published by your very capable and attractive staff a year in advance. If you were to go onto your website now, you would see all of your meetings for the remainder of the year. Not the agenda, but the notice of time and date of the meetings. Excuse me. So you're covered. If you have the best notice in the world, published a year in advance, and the only place you publish it is in the basement next to the boiler room, what good does that do anybody? And so we're going to say the notice has to be published in a location where a member of the community could become aware of it. We used to use what was called a newspaper of general publication. A variation on that would be the newspaper of wide circulation. Municipalities, counties, towns, particularly in more rural settings, still use that. The idea is to prevent county government from, say, for example, auctioning off seized property, and the only notice they put of it is in the Costco flyer or the Toys R Us flyer. And let's print it on newspaper. We gave notice. No, has to be a newspaper of general publication or a newspaper of wide circulation. We have the widest circulation of all now, and that is the internet. And so we at a bother with newspaper publication or newspaper notice. Notices of your meetings are going to be published on your board's website. They're also going to be published on the larger Department of Commerce and Insurance website. And then I've become aware too now that there is an email blast notification system, which is kind of cool. Miracles of modern technology. So somebody can sign up and say, I want to know about the next meeting of the Alarm System Contractors Board. Got an email a little bit ahead of time so that they know. Pretty cool. All the facts and circumstances, which is a legalese way of setting, you got to do them all. You can't do extra on one and then skimp on the other. You can't say, well, we published the notice of the meeting 3 years in advance, and so now we don't have to bother too much about the contents and the agenda. You got to do everything. Question came up at a previous board meeting. What if we went behind closed doors and did our substantive discussion of our business behind closed doors, and then came out into the sunshine, then got into the meeting room, got on the record under the gavel, and repeated the exact same conversation verbatim? Is that a violation of the Sunshine Law? And the courts are going to say yes. Not only is that a violation of the Sunshine Law because you've undertaken to discuss your business off the record, now you're also committing fraud on the public. You're piling on by trying to cover it up and say, no, we really didn't do it in secret. Look, here it is on the record. And so there's another case called Nice, and the Nice case opposition that if you end up doing that in order to fix the violation, in order to cure the violation of the law, you would have to have new and substantial discussion about it on the record in order to make that not just a sham dispute. We talked about the legal effect being nullity and how that can have pretty profound consequences as it falls down. Practical impact as well. If you get sued, as I've said a number of times, if you take nothing else away, take this. If you get sued, you've already lost. In terms of the costs, the time, your staff's time, having to come to Nashville to give depositions and give testimony in court and so on, and it gets old very quickly and it gets expensive very quickly. In a nutshell then, it's designed to protect the public. Designed to make sure that regulatory board and commission business is conducted in a way that's accessible to the public so that they can be present. It absolutely applies to you as a board, but also in your individual capacities as board members. Now that can be a little bit confusing. When you're acting as a private citizen, driving your car to the grocery store, taking your kids to school, then you're not subject to it. When you're acting in your capacity as a board member, then you are subject. What you say regarding board business should be on the record. All gatherings of more than one member are meetings. Unless you bump into each other in the grocery store, then it's not a meeting if it's a chance encounter. But then you know that you can't talk about board business there. So if there's more than one of you in the room talking about board business, that's a meeting. It's got to be on the record. It's got to be properly noticed. If there's only one of you at home staring into your mirror talking about board business, well, then it's not a meeting. You might have other problems. The only exception then is that executive session. That's your opportunity to speak with your board attorney, Mr. Kilgore, Ask him any questions you may have related to any actual suit or potential suit, but you can't decide substantively during that. And again, as I mentioned, it's his job. Now we're getting into debate or deliberation. Now it's time for y'all to go back in the room and get back on the record. And for every meeting, you have to give adequate notice in content, location, and time. Violative acts are void. The best way to protect yourself is to be very scrupulous, folks. I used to have on that slide, be paranoid. And then some people actually got paranoid and got to the point to where they felt like they were paralyzed and couldn't make decisions. And so we had to go back and clarify. This is not a talk that is designed into you, or as I said earlier, to waggle the collective legal finger at you. That's not the point. You know what's out there, to give you a broad overview of what the law is, what you're responsible to do, and to let you know, as I say there at the end, if there's any doubt in your mind as to whether a member of the public would object to what you're going to say or where or how you're going to say it, they probably will. And so it's best to avoid those kinds of situations, avoid the appearance of impropriety.
Thank you.
Madam Chair, I would like to make sure that we acknowledge that Board Member Karen Jones is now present.
Thank you.
And if we could, of course, we'd like to thank Mr. Damon for his presentation. And if we could take a small break.
Certainly.
Our attorney needed to go to his office to get some
Okay.
more material.
We're going
Thank
to
you.
take a 20-minute recess.
No, I didn't mean that in that way.
Did they go to University of Memphis, or?
Yes.
Well, I like the answer too.
Okay, folks. We're back on the, we're going to reconvene our meeting. We're back on the record again.
Ready? Are you ready back there, Rhonda?
Yeah, we're already. Next on our agenda is the legal report by Mr. Kilgore. Are you ready to proceed?
Yes, ma'am, I am, but I'm going to go ahead and we have one more legal matter to take care of.
Okay.
Prior to that, I'm going to go ahead and let Miss Robin Ryan, your litigator, come up and speak.
Okay.
I am a litigator. Litigator means I get to try the cases. Andrew, was doing your cases in the past. Like to talk about today is one we have scheduled for tomorrow morning that I'm asking your permission to go forward with an agreement. Because the issues involved, we really believe that at the conclusion of a discovery they get that is pertinent to what we have here, and to keep us informed. I'm asking you today to give me permission and approval to allow to file that agreement.
Madam Chairman, I make a motion that we allow council to proceed with the agreed order.
Okay, we have a motion by Mr. Roberts. Do we have a second?
I'll second the motion.
Okay, and we also have a second. All in favor voice by saying aye.
Aye.
All opposed?
If
Granted.
there is another matter scheduled for tomorrow, I believe that it's Out that you don't approve, what I will do is continue that one to another. If indeed it is not approved, the next date that we would have for hearing would be.
Thank you.
Get to her point about that matter scheduled for tomorrow. It's a case for representment. You have already authorized previously a consent order and civil penalty. And as she stated, it was scheduled for tomorrow as the civil penalty was not, the consent order was not accepted. This is case number 2012-019743, and it's on the last page of my legal report. I'm kind of jumping ahead on you. I was going to do it at the end, but since we're discussing matters in litigation, I'll go ahead and do it now. This case, like I said, was originally presented, and a consent order with a civil penalty in the amount of $5,000 was authorized against respondent DQA for allegedly fraudulently transferring accounts between his employer at the time and his alarm company, his own alarm company, which was in an expired status at the time. Since the board's authorization of the civil penalty, the complainant has withdrawn the complaint and has stated that respondent is now DQA for her company, and she does not wish to pursue any further action. Previous to her statement that she does not wish to pursue any further action, investigation was conducted where cooperation from complainant company was not found, and the evidence to substantiate the allegation in the complaint seems to be tenuous at best. And after discussion with litigating counsel, Ms. Ryan, and due to the lapse of time, the insufficiency of the evidence, and complainant's failure to provide further evidence substantiating the claims, and her wish to withdraw the complaint altogether, my recommendation is that we close this matter.
I understand that the complainant subsequently hired the person that she filed a complaint against as her.
Yes, ma'am, that's correct.
And then suddenly there was a lack of evidence to support the complaint in the first case, in the first place. How
Upon
surprising.
right, but upon reviewing the file and discussing it with the litigating counsel, there's not, any evidence to support the allegations.
I mean, I question there not being, because we obviously assessed a civil penalty, we had to have something to.
I think in the beginning, when the case was fresher and there were some pretty strong allegations made by the complainant that he was transferring accounts or withholding accounts fraudulently from her. I think that there was some personal issues involved between these two in the first place, and this was one of the complainant's ways to get to him, but now there doesn't appear to be strong evidence to go forward with a case in a formal hearing.
Sounds almost like a domestic case.
Actually, yes, there is some. Actually, in fact, there is some domestic matters involved, I believe. Yes, sir.
Would it be plausible for the legal staff to send this original complainant a letter about making accusations and then withdrawing and so forth? Would that be proper, Ms. Ryan?
If you're asking me, it's actually up to Josh.
Josh, either one.
Let me just explain sort of where we are. Josh and I.
Necessarily punish her, but maybe just a letter.
I don't think that we.
don't know if it rises to the level of any misconduct under our
That's what I was getting
statute.
at, is if
You're
it
right.
does rise to, not necessarily misconduct, but kind of like the letter of warning that we sometimes
Right.
send out.
We
just
could
don't-
always send a letter of warning, but,
That's what I
because
was
it doesn't
saying,
have
a
any
letter of
particular legal effect, but.
Right, but a
But
letter.
this is really rather embarrassing for the board.
Right.
We took what I would consider a serious action when we looked towards a civil penalty of $5,000. That's, to me, in my mind, a serious action. And so we're saying that the board took serious action, and now there's not any evidence to have substantiated that we should have taken that action in the first place. I find that embarrassing. That we may still have to decide what to do about it, but still, I'm not particularly happy with that. If we didn't have the evidence, sufficient evidence in the first place, then I'm wondering why we took that particular action.
Let me speak to the litigation portion of it, just so you understand. First of all, if you're talking about filing an action or some sort of
Right. We'd have to open the complaint against her, and again, I don't know that there's any conduct on her part that falls under a violation of the Alarm Act as it stands today.
And let me address the rest of the litigation. This is true here, and it's also true in private practice. Lawsuits and things will start, allegations will be thrown, and there ultimately an investigation will then either reveal that not the complainant's interest in going forward. Our burden is difficult. Our burden as the state is that we have to show beyond the often, as he suggested in this case, the investigation showed there wasn't sufficient. We also have an internal guideline that when cases are in a particular case, for instance, if it's then moved to the formal hearing status and often go forward, and in the course of discovery for a trial, we'll discover that there isn't enough to support a
Well, I agree with you to a degree, not to interrupt you, but, I mean, there had to have been some type of substantial evidence presented to this board originally as to agree to a $5,000 civil penalty. But then it says cooperation from the company was not found and evidence to support the allegation. Why are we just now hearing about that when we were not told this at the initial time?
I don't know, because I wasn't here to present it.
I mean,
don't think
this
that
is the
Josh-
question I'm throwing out because I'm not clearing my mind, because I felt like the board takes these matters on an individual basis and doesn't just rubber stamp them. So there had to be something presented to us
And there
that
probably-
we
And
agreed.
there probably was, and based on the allegations, it probably sounded very serious, and
I understand what you're saying, and I appreciate it fully. However, in the past, this board has generally refrained from taking serious actions based on an allegation. And so I'm not disagreeing with what you say, not at all, because, and I do understand that additional evidence comes up as you go into discovery for a more formal hearing. But again, the board would not normally take serious action just on somebody said thus and so, such and such. We try and feel like there's reasonable reason to take a particular action. And, like I say, I find this pretty embarrassing. Now, I understand the position we're in, and based on the situation we've got, we probably need to close the case. But beyond that, I'm a bit embarrassed by for the board in the way this has come about.
Well, I apologize too, again, I was. Where we are today. One more thing to let you know, though, anytime a complaint makes if they do anything about it, then the agreement is gonna become void. I'm not.
Action through the state, but that doesn't seem to be the case here. It's like voted on it, but then now, well, there wasn't anything there to begin with. It's almost like we were not given accurate information at the time of the
On the docket and file a motion to continue and reset.
I would not be in favor of that at all. I think that would be a mistake. If I fully respect your opinion that we don't have enough evidence to move forward. I realize that without the consent or help of the complainant, that it would be very difficult to prosecute some of these particular situations. So no, I don't think we should move forward at all. But nevertheless, that doesn't reduce my embarrassment on the board's actions for the first part. Madam Chairman, I would offer a motion that we concur with the recommendation of council, given the situation that exists at this point, that we go ahead and close this case.
We have a motion by Mr. Roberts to concur with our council's recommendation to close. Do we have a second?
Could I ask a question?
Certainly.
Would we normally respond to the complainant? Would they know an outcome, or would there be a response? Because you were talking about sending them something, basically, some sort of warning letter. I mean, could something be put in, or would a response even go to the complainant?
They generally just get notice of the action taken by the board. And in this case, she'll get a closure letter. I don't know that I mean, I understand the board's position and Madam Chairwoman's position about not filing false allegations to serve your own purpose or to get revenge or whatever.
Bad, I'm not.
Or
either.
withdrawing the, complaint later when we've already come to this point, but I don't think that there's anything in our laws or statutes that really we could, without opening a complaint against her, and again, I don't think that there's a violation of our Alarm Act for filing this complaint. So again, I think that she'll just receive the closure letter.
My only thought was if there could be something put in, and it's more than a complaint from an individual, because it is it's a qualifying agent that is licensed by the law, and they know what they're supposed to do, or the limits of it. Seems like something in that response might be warranted, but but that may not be possible. That may not be something we can.
Well, that's what I was asking a while ago, about something from, that obviously he says we can't, about following through with complaints or whatever, so obviously I don't think it's possible.
I mean, I think there's only one, and I'm just, I think that there's only one part of the statute that even discusses it. And under 6232 319, under suspension or revocation of certificate or license grounds. And only part that I see that could even remotely be this would be section 9, where it says found guilty by the board of misconduct, gross negligence or incompetence, but I'm not sure that normally I think that refers to the conduct of the alarm business. I don't know. Again, I think it's kind of stretching it to say that this rises to that level.
Probably we should not try and stretch it that far, but basically what we have if you look at this from an overview, it's almost like she filed a false complaint. The notice here refers to being withdrawn. It was withdrawn, and that kind of means it wasn't true. And
Well-
you can't withdraw it once you make a statement. I mean, it's been made.
Right. And
But, and so she really doesn't, the complainant, whoever that was, really doesn't have the authority to withdraw a complaint, because once it's been made, it's the property of the
Right.
responsibility of this board.
And I've explained that to both the complainant and the respondent in this matter, that, she can't, her withdrawal of it carries some weight, but the state is the actual complainant. She is not a party to this action anymore. She doesn't have legal standing to withdraw the complaint. However, it is something I think that the board should consider, due to the fact, as Ms. Ryan pointed out, that her testimony would be vital in substantiating the allegations in the complaint. I think that that's why, again, I apologize for the embarrassment on part of the board, and I do understand your position. However, at the time that the board authorized the consent order, the civil penalty, there was much stronger allegations, and the thought was that the complainant would be testifying at a formal hearing, and without her testimony, the case kind of falls apart.
And I understand, without the consent and cooperation of the complainant, the case does basically fall apart. But if it didn't happen, then she filed a false complaint. If it did happen, which we were led to believe, then then there was activity here that was not in accordance with the way it should have been. Now, that still leaves us with the
Well,
situation that, can we proceed forward with it? And no, I don't think we can. That's the reason I made the motion, which I don't believe has been seconded.
And I'm
that,
sorry, I mean,
we
if the
close
board
this.
feels it appropriate, I mean, in this case, we could do a letter of warning to this respondent, putting him on notice not to engage in that conduct again. We might not have the evidence to go forward on a formal hearing and enforce discipline, but we could still have it in his file that, there's been this allegation made of this activity prior, and while it may or may not have happened, I mean, it could have happened, but having the proof at trial is a different thing altogether.
All together.
Okay, any more discussion? We have a motion by Mr. Roberts to concur with our council's recommendation to close this matter. Do we have a second?
I'll second.
A second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion to close carries.
Thank you.
Thank you very much.
Thank you.
I don't know that we've ever had a situation quite like this before. This is kind of a first.
Well, and I think my concern is I don't want people to think that they can start using the board as a whipping post, that if they have a information what they want them to be, and that seems to be sort of what happened here. Case 1.
Okay. Case number 2014-003931. Complaint was established when board office received a consumer complaint regarding respondent advertising without the benefit of a license and engaging in improper conduct. Investigation, however, confirmed that respondent states they are ceasing all operations regarding alarm systems contracting in Tennessee. We had a prior complaint against this respondent that I believe we closed because they were ceasing business, and there's no evidence that they are continuing alarm operation here. Therefore, my recommendation is to close. These, I believe, the most recent ones were not too far apart, but we have had prior complaints against this particular respondent, and they're still paying. I believe there's still a large outstanding civil penalty that they're paying. However, I don't know the status of that right now due to the fact that they've ceased operations here and closed their doors, but that's a matter for collections.
I was just wondering what the time period was
Right.
between the original complaint and then the second one, if they're both, on both complaints, they're claiming they're ceasing operation, if that was,
That was within, I believe it was presented at the last board meeting.
okay, we have a motion by Mr. Kilgore to close this matter. Do we have a motion?
Madam Chairman, I make a motion we concur with the recommendation of council and close this particular case.
Okay, we have a motion and a second to concur with our council's recommendation and close. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-007501. Complaint was established when board office received correspondence from respondent that did not have company certification number displayed. Respondent admits that this was an oversight on their part, and they have taken steps to ensure future compliance by adding certification numbers to all email signatures and Facebook and Twitter accounts. My recommendation is issue letter of warning to respondent DQA regarding properly displaying company certification per TCA 6232-316D.
Madam Chairman, I make a motion that we concur with the recommendation of council and that the council issue a letter of warning.
Do we have a second?
Second.
Okay, we have a motion and a second to concur with our council's recommendation to issue a letter of warning. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-006781. Complaint was established when a termination notice was received from respondent for an employee terminated in August 2013. We received that on February 25th of this year. Respondent states that he is fairly certain but has no documentation that the notice was sent out a day after he signed it, which was on August 24th, 2013. Respondent states he has had issues in the past with mail being significantly delayed when sent to the board office and takes this matter very seriously. I wanted to point out that respondent has been licensed since 2006 without any board discipline, and my recommendation is to close.
Madam Chairman, I make a motion that we concur with the recommendation of council and close this particular case.
Second.
Okay, we have a motion and a second to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-006771. Complaint was established when board office received a termination notice on 2/28/14 that listed an employee's date of termination as 8/15/2012. This notice is well outside the 30-day time period allowed by Rule 0090-01-.069K. Therefore, recommendation authorize formal and send a consent order with a civil penalty in the amount of $50 for failing to timely submit one termination notice.
Josh, what was that case number again?
This one was 2014-006771.
There you go, you're on there you go.
I've got them up on the screen too, Ken, if you want to look at them, they're up there too.
I'd make a motion to concur with staff or with council.
Second.
We have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
2014-007491. Complaint was established when board office received correspondence from respondent that did not have company certification number displayed. Respondent admits this was an oversight on their part, and they have taken steps to ensure future compliance by disposing of all old stock letterhead that did not list the certification number. My recommendation is to issue a letter of warning regarding properly displaying company certification per TCA 6232-316D.
Is this the same company that a previous case was against?
No, ma'am.
Okay.
Madam Chairman, I make a motion that we concur with the recommendation to council and send a letter of warning in this instance, dealing with this case.
Second.
Okay, we have a motion and a second to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-008791. Complaint was established when board office received two termination notices on 4/2/2014 that listed an employee's dates of termination as 12/31/13 on the forms. Although it appears this notice is well outside the 30-day time period allowed by Rule 0090-01-.069K, it seems that respondent attempted to notify the board timely by sending in the forms within 30 days of actually terminating the employees in question. Respondent states that the date of termination date listed is actually the date the employees were laid off and the forms were sent in when determination was made that employees would not be hired back. My recommendation, therefore, is issue a letter of warning to respondent regarding properly filling out termination notice forms with the date of termination line listing the actual date of termination as opposed to the layoff date to avoid future complaints.
Madam Chairman, I make a motion we concur with the recommendation to council. I think that in this particular case, the respondent was trying to do what was correct. I think changing the form would make a lot of sense because I know that we have encountered situations where we would lay someone off temporarily and not terminate them until some later date. So I think that what our council is recommending here makes a lot of sense. It was an issue that we've been wrestling with exactly how to do that, so it makes a lot of sense. So I think a letter of warning is exactly appropriate here.
Okay. We have a motion by Mr. Roberts to concur with our council. Do we have a second?
And I'll second.
Okay, we have a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-001761. Complaint was established when board office received an anonymous complaint stating that respondent was employing unregistered personnel to sell alarm systems, one of which had already been denied previously for his criminal history when he attempted to gain his registered employee license. It should be noted a letter of warning was previously sent to respondent regarding the same employee and unregistered conduct when it was alleged that the employee in question was selling alarms door to door despite not being properly registered. An investigation of this matter uncovered evidence in the form of a sales contract between a commercial business and a respondent company that was signed by the unregistered employee in question as, quote, sales representative. Further, a copy of a business card was discovered showing the employee's name and titled him as a security consultant with the respondent's company's letterhead above same. Respondent owner denies he is selling alarms and state that he is a telemarketer for satellite services. My recommendation is we authorize formal and send a consent order with a civil penalty in the amount of $1,000 for failing to timely register an employee, requiring registration per TCA 6232-304G and J, and also TCA 6232-312 Section A.
Company licensed to sell alarms?
They are.
and satellite as well. But the unregistered, the person that the board would not register because of criminal history, whatever,
Right.
the case is that he has been selling alarms
As a subcontractor?
No, as an employee.
as an employee.
They sell, the company that is registered as an alarm company also apparently deals in satellite sales. This has been a previous allegation that we sent a letter of warning on.
It says that you have, that investigation of this matter uncovered evidence in the form of a sales contract between a commercial business whom is registered, licensed, correct?
Well, it's between,
They
And
sold
a
the
business.
alarm.
right,
No,
it's,
they sold
and
the
a
alarm to a
respondent.
business.
it's between, I'm sorry, it's between the respondent, yes, and a commercial business where they were selling the alarms, and it has the unregistered employee's signature listed as the sales
Sales
representative.
contract.
So they're actually hiring him as a subcontractor and not registering him because they know they can't get him registered.
No, they're hiring him as he's a direct employee
They
of
sold a
respondent.
commercial, I think you're
In
saying,
spite of the fact that he couldn't be registered.
he's selling alarm
And this is the
systems to
second time
commercial
that this
business.
particular employee has
versus
been
other
alleged to be
residents.
selling alarms. And last time we felt that a letter of warning due to the fact that I think his registered employee application was still in process and had not yet been denied at that time. But now that they've already received a letter of warning in their file and have been put on notice that both the registered employee has been denied due to his criminal history and the fact that the company respondent here has been put on notice previously that this individual should be registered and is not. And he's.
So they had already received the denial for the employee registration
Yes, ma'am.
before this person went out and sold this commercial alarm system, which we have a copy of the sales contract. There wasn't any overlap of time where it could still been in pending or anything.
I'm not entirely sure about the time frame, but the fact that we actually have a sales contract with this individual's signature on there, whereas previously, on the previous complaint, we did not. I think the previous complaint was a consumer complaint without a contract, where it was a more of a he said, she said. This gentleman was approaching her condo or what have you, but now we actually have a commercial business where he did in fact sell an alarm, and the respondent's stance has been throughout this that he's never sold alarms, that he simply is a telemarketer selling satellites. I think that the evidence now is pretty obvious that he's been out.
Got alarm systems contract, he's got a license.
Not the
No,
registered, the
couldn't
the
get
employee in
registered.
question does not.
I'm not talking about I'm not talking
Right.
about the employee, but the company that he's working for
Mhm.
is actually licensed, but he is not a registered employee.
Right.
So the company could sell them, it's just that he's not allowed
Exactly.
to sell them. Okay.
Exactly.
Josh, I would also point out that I'm assuming that when the employee was not allowed to be registered, that there was a cease and desist order sent. And you might want to make a note of that, because then that puts this company in violation of a cease and desist also.
That's correct.
Right. The letter that goes out does say he shall immediately cease and desist from whatever activity requires registration.
I
So-
want to include that or a note to that effect in the file, so if this proceeds, then you've got a violation of a cease and desist order as well. Madam Chairman, I make a motion that we concur with the recommendation of council. I think that $1,000 consent order is fully appropriate in this case, and I'd like to see it brought to a conclusion.
Second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter for a consent order in the amount of $1,000 and authorize a formal hearing. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-004281. Complaint was established when two employees were listed on the company renewal form that had never submitted employee registration applications to the board office. Respondent company states that the two individuals in question were mistakenly listed on the company renewal form, but that they did not need to be registered in Tennessee as they do not physically work here. Respondent is an out-of-state company certified in burglar only, and subsequent communication from board staff and the company indicate that the employees have access to sensitive customer account information. Respondent states that they have no accounts in, nor do they do business in Tennessee. However, they do have, obviously, a Tennessee alarm contractor's license, which begs the question, why do they have a license if not to do business here? Therefore, my recommendation is authorize formal and send a consent order with a civil penalty in the amount of $1,200, which would be $50 times 24 months for failing to register an alarm employee for a period of 24 months per TCA 6232-312A, and also investigate to determine what extent, if any, they conduct business in Tennessee in order to determine if they have employees that require registration. I would also go ahead and point out, anticipating your question, why is it only against one registered employee? I believe that the other individual was their QA, which he does have a QA license. He just merely needs to be listed on the renewal form, so he was not a registered employee requiring the registration.
Madam Chairman, I make a motion that we concur with the recommendation of council.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
We have a second by Ms. Jones to concur with our council's recommendation to authorize a formal hearing and send a consent order with a civil penalty, $1,200, with the details, and also to approve an investigation to determine what extent, if any, they're conducting business in Tennessee. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-007471. Complaint was established when the board received correspondence on company letterhead from respondent that did not display company certification number. Respondent admits this error but states it has limited contact with the state of Tennessee and has taken steps to correct this and keep the error from happening in the future. My recommendation is issue a letter of warning to respondent regarding properly displaying company certification per TCA 6232-316D.
Madam Chairman, I make a motion that we concur with the recommendation of council.
And I'll second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-007481. Complaint was established when the board received correspondence on company letterhead from respondent that did not display company certification number. Respondent admits this error and states it has taken steps to correct this and keep the error from happening in the future. Therefore, my recommendation is a letter of warning per TCA 6232-316D.
Madam Chairman, I would move that we concur with the attorney.
Okay. We have a motion. Do we have a second to concur with our council's recommendation?
Second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-007451. Complaint was established when board office received a competitor complaint alleging that respondent was engaging in alarm system contracting without first having an alarm license. Respondent owner states that he operates an audio-video company, but that he has, in the past, run alarm wire and hung some alarm parts. He says he has referred to some local licensed businesses for monitoring and has never advertised as an alarm contractor. He states he no longer wires or hangs any alarm parts. Respondent states that he is the godfather of complainant's children and he has known him for over 20 years and that he is shocked by this complaint. Respondent states that he has spoken to complainant about this matter and was told that the complainant just wanted to scare him into getting a license with the alarm board. Complainant indicated same in his complaint. Complainant stated that respondent had been engaging in alarm work since at least 2006 for several contractors, and that he had told respondent he needed an alarm license several times. Regardless of the reason behind the complaint, respondent admits it had engaged in running alarm wire and hanging alarm parts, knowing that it needed a license to do so. As respondent states, he was in the alarm business prior to this latest venture for over 15 years. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $500 for engaging in alarm system contracting without first obtaining an alarm company license per TCA 6232-304A.
What is the basis of the penalty amount on this one? I mean, a lot of these are already set up amounts or.
Yes, sir. This one's.
We have a guide that we
This is
can
the
follow, but
guide
we don't have
for.
to stick to it.
I mean, it troubles me that like we just assessed the
Correct.
penalty on a licensed contract, a licensed company, and here we're gonna assess one less for somebody that's not even licensed. They're not complying at all, and he even admits he's done it for a while.
Right. Well, I think the first matter is distinguished, being that we had put them on notice before, and it's the same unregistered person. However, I don't totally disagree with you. I was looking at the guide, and the $500 is for what we generally do for first offense. However, it does appear that he has been doing this for a while, so if the board feels that a stiffer civil penalty is in order, I can certainly understand and am open to the board's authorization on what they feel is appropriate for a civil penalty.
I mean, by their own admission, it's been at least 2006, which is 8 years.
I think he says there that he had been in the business, not necessarily doing this, doesn't he?
I think that he was previously,
Radio, and he run wires and hung alarm
I think
parts.
he even previously here worked for the complainant previously. So his 15 years experience was not all unlicensed. However, someone who has been in the business that long should at least know that they need a license before doing any of this work.
Madam Chairman, I make a motion that we authorize a formal hearing and send a consent order with civil penalty in the amount of $1,000 for engaging in alarm system contracting without first obtaining an alarm company license per TCA 6232-304 subparagraph A.
And I'll second.
Okay, we have a motion and a second to authorize, but increasing, to concur with council's recommendation, but to increase the civil penalty from $500 to $1,000. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
We might point out here, just for information, that the board over a significant period of time has put together a series of guidelines with an attempt to try and treat everybody equitably, and again, not have penalties for one person that'd be way out of line with the way we had treated someone else. And as was pointed out, while they are guidelines, they're not firm rules,
Bound to them.
but. Yeah, that's where many of these numbers have come from. The basic idea is if someone has done something inappropriately the first time, then the penalty is lesser than it would be under circumstances where it's been a repeat offense or other circumstances given.
I thought that was the case. I'd just like to see us not punish people as harshly that are trying to comply, that as ones that are just blatantly going against the whole thing.
I agree.
The guidelines pretty well take that into consideration, but again, each case has to be discussed and evaluated on its own merit.
Okay.
Thank you. Case number 2014-008841. Complaint was established when board office received the alarm system company's 2014 renewal form, wherein the name of one previously registered employee was missing. Respondent DQA failed to submit a notice of termination for this employee within 30 days as required by Rule 0090-01-.069K. Respondent states that this was an oversight and new procedures have been put in place to ensure this does not happen again. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50 for failing to submit timely one termination notice.
I'll make a motion to concur with staff.
Okay, we have a motion to concur with our council's recommendation. Do we have a second?
Second.
We have a motion and a second to concur with council's recommendation. All in favor voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2014-008801. Complaint was established when 2 termination notices were received from respondent DQA outside the 30-day period allowed by rule. Respondent self-reported this violation and stated that there is no excuse other than the company was going through a major crisis as it was discovered the former CFO had been misappropriating funds for quite some time that was only discovered some years later, which nearly put the company out of business. Respondent is asking for leniency from the board in this matter based on extenuating circumstances surrounding this oversight. I'm not sure that relieves them of the duty to submit the termination notice, so my recommendation is still that we authorize formal and send a consent order with a civil penalty in the amount of $100 for failing to timely submit 2 termination notices. I think I did put, if the board felt a letter of warning would be appropriate, that we could do that, given respondent's statement of the extenuating circumstances, but I was going to leave it up to the board in this matter.
Madam Chairman, I make a motion. They will authorize a formal and send a consent order with civil penalty amount of $50 for failing to timely submit the termination notices as indicated.
I'll second.
Okay, we have a motion and a second to authorize formal and send a consent order with a civil penalty in the amount of $50 for failing to timely submit the termination notices. All in favor voice by saying aye.
Aye.
All opposed? The motion carries.
And Madam Chairman, in making that motion, I was trying to take into consideration that this was a self-reported violation, which I think considers or should take into consideration that particular circumstance.
Okay, thank you.
Thank you. Case number 2014-006761. Complaint was established when the board office received a registered employee application on 3/12/14 that listed employment date as 8/10/2009. The employee application appears to have been filed approximately 55 months late. However, respondent states that the employee in question was hired in a position not requiring registration and was involved only in inspecting, testing, and maintenance of water-based fire protection systems. Respondent states that they are now attempting to register the employee so that they may reassign him to support fire alarm-related systems. My recommendation here is to issue a letter of instruction regarding listing the date as listed on the application, employed in registered position, rather than the employee's original hire date to avoid future complaints.
So he just put the original hire date in the wrong place. Did he
Well,
put the same date in both places?
I think that there's only one spot on
There's
the
There's a hire
registered
date and then
employee.
a date in registered position in there.
I don't believe so.
We changed registered position.
And I believe the board staff had tried to change it to what it is now, which is employed in registered position, to help clarify. However, it appears that some people are still overlooking that and putting original hire dates, as we have. I can tell you that the next number, 15 here, different case, 2014-009931, is the same respondent with the same allegation and the same response, that they put original hire date rather than the date employed in the registered position. And my recommendation would be the same, that we issue the letter of instruction, as these complaints are so close together and they have not been put on notice of this previously.
I mean, you and the staff are satisfied that this was an honest mistake. They've had him in an unregistered position, but then transferred him into a registered position, and it was just a simple mistake.
Right. I believe that they have not even transferred him as of yet. I think that they're planning on it, but they're trying to get him registered now.
Okay.
Madam Chairman, I make a motion that we in both of these two cases that Josh has just brought before us, send a single letter of instruction as he's recommended.
I'll second, and to make note that I was wrong. I looked at the new application, you're right, it just has one date. I was thinking about the old ones.
Okay, we have a motion and a second to concur with our council's recommendation in both of these matters to issue letter of instructions regarding the correct date on the registered employee application. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. So we took care of 14 and 15 for you.
Thank you. Case number 2014-006751. Complaint alleges that respondent failed to timely notify of the termination of their DQA within the 10 working days required by law. Respondent's QA was terminated 5/11/2012, and the board office has still not received a termination notice from respondent. It also appears respondent continued to operate without DQA from 5/11/2012 to April 2nd, 2014, a period of almost 2 years. Respondent also has no registered employees, which seems odd as they contract to monitor Tennessee installations. My recommendation, therefore, is to authorize formal and send a consent order with a civil penalty in the amount of $18,000 for violating TCA 6232-304B, C, and H, and also Rule 0090-01-.078. Also, I'd like to investigate to determine to what extent they conduct business in Tennessee and determine which employees may require registration, which may give rise to a separate complaint in the future.
So it's my understanding that they have active monitoring accounts inside Tennessee, but they're claiming no employees, no QA. Okay. I just wanted to
And we
make
still have
sure.
not received that termination notice of their QA. I think we received it via the QA's own notice to us, but not from the company that's required. Right.
But they do,
Oh.
they are actively conducting business in Tennessee in some fashion, is what I'm getting at.
Yes, they are.
Okay.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Okay, do we have a second in this matter?
Second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter on both recommendations. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-009951. Complaint alleges that respondent failed to register one alarm employee within 30 days of his employment date. Respondent states that employee began work for the company in a different area other than alarm work. When respondent moved the employee in question to a different division doing alarm work, he was registered timely. The employee registration form stated that the employee was hired 12/31/13 and application was received 3/12/14. And respondent states that the employee did not engage in alarm work until 3/1/14. My recommendation is to issue a letter of instruction stating that respondent should list the date the registered employee is hired into the position requiring registration rather than the actual hire date at the company to decrease the likelihood of future complaints.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
We have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-007511. Complaint was established when the board received correspondence in the form of an email from respondent that did not display company certification number. Respondent states that 6232-316 read in conjunction with Rule 0900-01-.0712 is meant to apply only to advertising materials and other materials sent to the general public. Respondent states that this was an email that was sent directly to alarm board staff, thus there was no violation. In reading the applicable statutes and rules, I see no provision that exempts emails from an alarm company, regardless of their purpose or recipient, from containing the certification number. I still recommend issue a letter of warning, as we have to other respondents for the same violation. regarding properly displaying the company's certification number per TCA 6232-316D.
Madam Chairman, I make a motion we concur with the recommendation of the council.
We have a motion, do we have a second?
Second.
We have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-025341. Complaint was established when it was alleged respondent company had placed a bid and was engaging in CCTV installation without first being properly certified by the alarm board. Investigation found respondent's website to be advertising CCTV surveillance systems, and respondent admitted to submitting a bid to install the CCTV system. Respondent states that they have been in the business of running cable for many years under their contractor's license, and they're trying to branch out into other industries. The respondent admits their error and states they withdrew the bid as soon as they realized they were in violation of the law. Respondent states that they intend to follow all licensure requirements prior to conducting any work requiring an alarm company certification. My recommendation is issue a letter of warning regarding engaging in alarm systems contracting prior to obtaining certification from the alarm board per TCA 6232-304A, J, and K.
Y'all talked to this company. Did you happen to ask how many other CCTV jobs they had bid on and completed?
I believe they stated that this was their first and only, and that they withdrew it as soon as they learned of the violation.
They've been in the business of running cable for many years under their contractor's license.
Running cable, not doing CCTV, I don't think.
Running cable is considered alarm contracting if it's for alarm.
My understanding is that they weren't.
It might have been.
It just says if you sell, install, etc. I can look up the code, but
Right.
it says it's unlicensed activity.
Did they think they were exempt before or because of the contractor's license? Did they have a,
Doesn't matter what they think. I mean,
Sounds like they may have been running cable TV or structured cabling for internet or
From the name of the
Things of that
company,
nature.
that's what it would appear. Yes.
Madam Chairman, I make a motion we concur with the recommendation council, issue a letter of warning in this case.
Okay, we have a motion, do we have a second?
I have a little bit of trouble with this one. This one's, because this falls back into, this is somebody that's not licensed at all, and we're, hadn't installed. If he's advertising, that's in violation of the law. I get, my trouble is that there's not a fine, I guess is the point, that if we're just issuing a letter of warning. Fines for people where they didn't timely terminate somebody. I mean, they're attempting to comply, but this person's not attempting to comply.
Josh, if I may ask, our guidelines, I don't have a copy of them with me. The guidelines consider a letter of warning on the first instance of something like this.
Well, I think that my reasoning was that they hadn't actually done the work, and I was trying to look at the investigation where it has a printout of their website to see if they're still advertising or if they've taken that part down.
Have they taken it down?
I'm looking right now.
Okay.
Actually, it does look like a copy of this website I have printed out on March 5th of 2014, they're advertising, we can provide the design, implementation, and maintenance for IP video surveillance, which looks like they're still advertising.
But you haven't checked it since March.
I have not personally, no, ma'am. If you would like, I can, we can table this one and I can check it during a break and
Let me ask
see.
you this, what was the date approximately that you or someone had contact with them, that they agreed to withdraw the bid and stop all advertising?
I believe that they had, like the date of this, hold on. That's the date I received it. Looks like around the end of March of this year, March 28th is when our investigator had contacted them. And that was when they said that they had already withdrawn the bid.
Madam Chairman, I make a motion that we table this till later in our meeting, which would give Josh an opportunity to see whether they have discontinued advertising or not.
Vote your motion down first,
We had no second.
because we hadn't, okay.
We had no second.
Motion to table would supersede a motion, primary motion.
We need a second to table.
Second.
Okay, we have a motion and a second to table this matter until Mr. Kilgore has time to do a little more checking. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. So we'll come back to this one
Okay.
later on in the day.
Yes, ma'am. Thank you.
Thank you.
Case number 2014-009961. Complaint was established when one transfer notice was received from respondent DQA outside the 30-day period allowed by rule. Respondent states that the employee in question simply moved from the Johnson City to Knoxville offices when the Johnson City office closed. The date of October 1st, 2013, listed as the hire date on the transfer form, was due to clerical error, according to respondent. No prior complaint history was found against this respondent. My recommendation is we issue a letter of warning regarding timely filing transfer notices per Rule 0090-01-.069K.
I'd make a motion to concur with staff, with council.
I'll second.
Okay, we have a motion and a second to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-008831. Complaint was established when one termination notice was received from respondent DQA outside the 30-day period allowed by rule. Respondent states that the employee in question died on or around 2/5/2012. Respondent states that it was an oversight that they failed to submit the termination form with the board within the 30-day period. Honestly, that's the first time I've heard that as being a reason for not submitting a termination notice, so I don't know if the board wants to authorize the usual civil penalty of $50 for failing to timely submit the termination notice. I mean, this was back in 2012, so it seems like a long period of time.
Josh, how did this complaint come forward? Do you know?
Most
In
likely, it
response-
looks like the termination notice was received, so they did go ahead and submit the termination notice upon finding that they had not. So they were attempting to comply.
So in essence, it was a sort of
Self-reported.
self-reported thing?
Yes, sir.
In response to you never heard it, just as it happened to me, and I didn't know whether to file a termination or write a letter saying he had died. And I had to call the office for guidance.
Okay.
So it does happen sometimes.
Yeah.
Madam Chairman, I make a motion that we concur with the recommendation of council, authorize a consent order with civil penalty in the amount of $50.
A second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-004261 and 2. Two respondents in this matter. A complaint was established alleging that 2 alarm contracting companies failed to submit termination/transfer notices. A termination notice for the employee in question was received outside the 30-day period allowed by rule. The date of termination was listed as 12/8/2013. It was not received until 5/1/14 from respondent number 2. Respondent number 1 failed to submit a transfer notice within the time frame allowed by rule, and I do not believe it's been received as of this date. My recommendation here is authorize formal send a consent order to respondent 2 with a civil penalty in the amount of $50 for failing to submit 1 termination notice per rule 0090-01.069K, and authorize formal and send a consent order with a civil penalty to respondent number 1 with a civil penalty in the amount of $50 for failing to timely submit the transfer notice per the same rule.
What's the connection between these two companies?
They are separate, same company, branch offices, 2 branches. One in Memphis, one in Nashville, I believe. Yes.
That's the connection between those?
Right.
Oh, okay, because I'm, okay.
Madam Chairman, I make a motion we concur with the recommendation of council and authorize a formal hearing and send a consent order to each of the 2 respondents for $50.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
We have a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-007461. Complainant, former DQA for respondent, filed a complaint alleging that respondent company was still using and operating under his DQA license after he had left the company and provided notice to the board. Respondent states that they were not using his DQA license and that they had requested an extension from the board, which they were granted. Respondent company did state the complainant had started his own alarm systems contractor company and that it was properly certified with the board. Complainant's company was never licensed. Respondent states that they subcontracted 2 jobs in Tennessee to complainant's unlicensed company, but that neither job was completed as complainant defaulted on those contracts and went out of business. Evidence, including copies of the contracts in question, was obtained to substantiate respondent's statements. Respondent further states that they no longer do business in Tennessee and have not since 1/10/2014, which is in compliance with their extension to find a DQA, which was set to run out in February of 14. My recommendation is issue a letter of warning regarding subcontracting to an unlicensed alarm system contractor per TCA 6232-304F, and also establish a complaint against complainant in this matter for engaging or offering to engage in alarm systems contracting without being duly certified per TCA 6232-304A.
Madam Chairman, I make a motion we concur with the recommendation of council to issue a letter of warning to the respondent company and that we establish a complaint against the complainant in this particular matter.
A second.
Okay, we have a motion by Mr. Roberts and a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
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 All opposed? The motion carries.
Thank you. Case number 2014-008781. Complaint was established when it was alleged a salesperson representing himself as selling for a company with a similar name as respondent company, when in fact he was selling on behalf of respondent, essentially approaching consumers with yard signs of complainant company and holding himself out to be representing them and not respondent in order to get them to upgrade their systems when in fact they were entering into a new contract with a different company altogether. Respondent company states that the salesperson in question does not sell for them, but for another authorized dealer for respondent. Respondent's counsel states they have forwarded the complaint to the authorized dealer and have stated that they are to cease sales practices like these immediately and to publish new training and marketing materials regarding this type of behavior. The authorized dealer has been added as a respondent. Well, no, they haven't yet. Sorry about that. We will be establishing a complaint against the authorized dealer in this matter based on these allegations. And we'll gather information for the next meeting. My recommendation as to this respondent here is that we issue a letter of warning about fraudulent or dishonest dealings per TCA 6232-319D. And to clarify, we're going to be opening a complaint against the authorized dealer that was holding themselves out as respondent here.
Okay, we have a motion. Do we have a second to concur with our council's recommendation?
Second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed?
This particular case was not a real clear one, with the respondents and the complainants sort of intermingled and mixed between the two. A little bit difficult to fully get wrapped around here. I would recommend that we also send, along with a letter of warning, a copy of the code of conduct that the board had adopted, so that would be included as part of the letter of warning.
Yeah, I don't think that the rules are ready for publication
Can't
yet.
do that yet?
We're still, I was going to give a rule update
That
after
would
this.
sure be
but-
beneficial, I think, in this case, to help them understand the board's position. Can we do that without, even though it hasn't been fully approved? And
Unfortunately, I think this issue's come up before, and you asked me to look into it, and I looked into it per your request, and I don't think that we are authorized to send those out to anyone yet because they're not fully ready and approved. They're still making their way through the.
They don't actually exist yet.
Well, and it doesn't sound like
Right.
this, who this respondent is not where the issue really lies. The respondent is the dealer program, not the person, not the company that was actually in the field.
Yeah, the company that's actually in the field will be getting a new complaint open against it, and they can answer because they never responded, even though this respondent states they forwarded the complaint to them. Since they weren't named in that complaint, I don't think they were compelled to respond, but when we open the new complaint, they will be compelled. And we can see if there's any further investigation needed after we get their response or what needs to be obtained.
I think the confusing is respondent company states that the salesperson in question does not sell for them, but for another authorized dealer for respondent. I think that's kind of what,
Oh,
we've got so many
right.
different respondents in there that it's kind of hard for us.
Yeah, no, I
Probably see
understand.
us when the complaints come in.
Oh, I can imagine, but,
It's like, wait a minute, what company? Well,
Yeah,
well, next time we're gonna request that Josh do little drawings up on the board so we can keep
We'll make
track
a-
of who's over here and who's doing this.
I can use Microsoft Paint if you'd like.
That's right, yes. Something
Okay.
visual for us.
Case number 2014-011111. Complaint was established when we received a qualifying agent application which listed the applicant's previous experience with respondent company Applicant was never registered by respondent in the time period he worked there from, which was off and on from 3/31/03 to 8/7/03 to 6/3/04 to 8/12/04, and from 7/8 to 8/18 of '05. And employee also worked for respondent from November 1st, 2009 to present, but was finally registered April 29th of 10. Therefore, based on the information given by respondent, the employee in question worked for a period of at least 10 months prior to him becoming registered with the board, if my math is correct. Therefore, authorize formal and send a consent order with a civil penalty in the amount of $500, which was $50 times 10 months per TCA 6232-312C.
These dates that he worked there, starting with 3/31/03 up through the other ones, are they saying, is he saying that he was in a registered position
Yes.
all that time? And that's
Well-
what he's using his education on to get his QA license?
Yes.
And there's no record of him having been registered during these periods to support his previous experience.
Well, there wasn't. I believe we have a letter from the respondent in this matter stating that it was obviously an oversight on his part.
Employee or the QA said it was, or the owner of the company said it was oversight?
The owner of the company. Normally, we hold the company responsible for failing to register. I think it's a smaller company, and actually, in this circumstance, I believe that the owner, respondent here, I believe that the employee in question submitting his QA application is actually the owner's son. So, looks like he failed to register him, but I think he just saw it as him working kind of under him for the summer and stuff like that. But I still think it's a violation. But I think that's what was going through his mind when he was employing him on these dates of a couple months here and there. But now that he's trying to use that experience for his QA license, it's become an issue.
Document his experience because he wasn't registered.
Right.
And he is registered now.
Yes, as of April 29th of 10. So
But
he's
he
been
wants a-
registered for four.
But he
for
wants a
4
QA
years.
license even though he can't document 5 years of experience.
Well, in the past, we have, I believe the board has, in these instances, still gone ahead and approved the undocumented experience. It's just a little bit different situation. I mean, I don't think that the board wishes to punish the employee from getting his QA license based on a failure of the company that he worked for.
I'm just asking.
Oh, right. No, I'm just trying to clarify that I think that this is how we've handled it in the past.
So the company will just pay the penalty and run him on through the chute.
I believe so, yes.
So he'll get credit for the.
Well, he'll at least get credit for it. Right.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed?
Motion carries.
Case number 2014-009941. Complaint was established when one employee registration application was received on 3/12/2014 with a hire date of 12/2/2013 listed. Respondent company states that the employee in question was hired that date on a 90-day trial period and was attending training classes at their Kentucky office during this time and was not working in Tennessee. There's no evidence to refute respondent's claims, but it appears future complaints would be avoided by providing a letter of instruction advising that respondent list hire dates of when the person is actually starting the position requiring registration rather than the date that they begin their training trial period. Therefore, my recommendation is issue a letter of instruction regarding properly filling out registered employee application reflecting the date the employee actually starts to work in the position requiring registration.
Madam Chairman, I make a motion that we concur with the recommendation of council.
Second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2014-010791. Complaint was established when one termination notice was received from respondent DQA outside the 30-day period allowed by rule. Respondent states that the employee in question resigned on 3/29/14. Respondent states that there was an oversight that they failed to submit the termination form with the board within the 30-day period. We have received that termination. It was just late, outside the 30 days. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50 for failing to timely submit one termination notice per rule 0090-01-.069K.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Oh.
Legal report.
Oh, thank
No?
you. I believe going back to the one that the board had the question about that we tabled
Okay.
earlier, my paralegal was kind enough to go look that up. Thank you, Margaret. It was case number 2013-025341. It appears based on what she has just found online, dated today's date, June 19th, 2014. It appears that this respondent's still advertising, doing video surveillance on their website. Therefore, I'd like to amend my recommendation to fall in line with our normal guidelines, which would be $500 civil penalty for the first offense.
I'd make a motion to concur with council.
And that's going to be accompanied with a cease and desist, correct? Since they're
Yes.
unlicensed activity.
Should they agree to the consent order that we send out, there's language in there that says they shall cease and desist from doing the activity that's causing the violation. So should the board find that they're still continuing to so act prior to licensure, that could constitute another complaint, higher civil penalty, all that.
We have a motion to concur with our council's recommendation amended for a $500 civil penalty and authorizing formal. Do we have a second?
Second.
We have a motion and a second. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Thank
Thank
you.
you, and thank you, paralegal.
I've got a question. On some of these where they're all very similar, could some of it be done like a consent agenda or something where they're all, or do they have to all be heard?
Well, each one has a separate number, but I suppose I could do a better job of trying to group them all together. And since they're all, I think when I started, we had different violations a lot of the time, but now that it's seems like we're getting the same ones over and over for the sake of time, and I'll just put them in, try to group them together and try to deal with them all at one time so we don't have to keep going through there. And
You're speaking just like the ones where it's, say they don't have their certification number or
right,
something like
or
that. but
failure
not
to
the
submit
ones-
termination notice, or I mean those
Well, I
may
don't
depend
know about
on
that.
how long, or
Yes.
well, the amount of termination notices received. The ones about the certification numbers could easily be grouped.
Like the ones on the application where the dates are wrong, if we're,
Then you have to look at the period of time and so forth on them instead of, because some of them's just a short.
Yeah, the
Years.
registered employee applications, those cause a little bit of an issue because the board generally does it by how long the employee in question has been working unregistered. Now, as far as the termination notices go, we do those on just the amount. It's like $50 per late termination notice. So those might be a little bit easier to deal with in at one time.
I guess my thought was if we had a list of 10 that were all very similar, that were all with regards to termination dates or something, and if we wanted to pull one of those out, we could say, well, we'd like to pull one for discussion, but if we could vote on all 10 together, it seems like that would move that along if there wasn't a need
It
to
will, except sometimes there's,
other
you have to
circumstances.
pick out, you have to kind of.
Let's do this. Let's grant our council some discretion in possibly grouping some of these. There were several that were very similar, each with the same recommendation that, for instance, they didn't have the certification number included in some bit of advertising. Let's allow or encourage our staff attorney to group those where it seems appropriate to do so and with a similar recommendation. So that's a good suggestion. Might speed things along just a little bit. Save reading each and every particular. I think it's a good suggestion.
Be required to each have a, yeah, you're gonna have to reach each.
They have
If
to be
it's-
done on an individual because they've got an individual case number.
Oh, but if the complaint was the same, that they did not include a
As long
registered,
as the case number is read into the record.
you'd have to include
Well,
the
I could
case
read,
number. But
I could read all the case numbers and state the allegation
Like the
and
first
the
offense and so
response, right?
forth, but, if it's a second or third violation, you'd have to kick it out, even though it was just a certification, for example, but.
for instance, today, and normally we don't have quite that many that seem to be repetitious. There seem to be an inordinate number of them this morning, but I think our staff attorney could group some of those and would still allow us to perhaps expedite some of the business and still deal with them in a reasonable fashion.
Anything else for Mr. Kilgore?
That concludes my legal report. I was just going to give a brief rules update that I alluded to earlier. The rules are in pre-review with the Attorney General's office. I've been in communication with them. They asked me some questions. I responded, and this has been a couple weeks ago, but I have not heard anything about those, and I was trying to give them time to review them and get back to me. And I do not know their timeline over there, so they are in the process, and once they're approved over there, they should be ready to go forward for rulemaking hearing.
What's the distinction between review and pre-review?
Well, that's a good question, but I'm not exactly positive of that myself.
Thank you.
Break for lunch?
Our appearance is here, if you wanted to go ahead and do that one. If you would look at your agenda under Exhibit H.
Stephen, Mr. James?
Yes,
Okay.
it is. And I believe he's got his qualifying agent with him as well.
Supervisor, qualified agent, you can call in.
That's okay. This one here, Madam Chair, is just a little different. Mr. James is here with the supervisor, but the qualifying agent, can I have your attention, please?
I'm sorry, we're having trouble with the iPads.
Okay.
How do we get out of one report and into the other one?
I always have this problem.
We'll go up to the top on the left-hand.
Oh, thank you.
That was the trouble we were having.
Okay.
No, some of these are very sensitive. You have to touch
yeah.
on a different part to get you back to the library, and that was
Library,
just, he couldn't get back to
Thank
the
you.
main library.
Yeah, we're going to
Yes.
H, so Mr. James is here, if you go ahead and sign in, please, and as stated, the supervisor's here, but the qualifying agent wants to call in, so we will be placing a call to the qualifying agent, but when you do if you vote on this, I will have to do a roll call vote, since we do have someone on the phone.
Do you want me to go ahead and call?
Yes, I believe.
Okay, no, Mr. James, identify yourself. And then you're
James Harrison is supervisor.
James Harrison.
Yes, ma'am.
I
Okay,
put the
you're
sign-in
correct.
sheet over there if you guys wouldn't mind signing in. You guys reviewed this at the March meeting and asked that he appear.
Thunder. Thank you. Mr. James, as you would, please give them a few minutes. They have not seen this before, and they'll need to look over it. If you would turn to, look at page 3, it does give you the charges, or what you're looking at there. He did supply a written explanation as well. Yeah, you just leave that up there, be fine. And you do have a court document with you as well in that packet.
Hello, this is Luke.
Hello, Lou?
Hey, can you hear me?
Yes, we can hear you.
Okay.
Just hang on for a second, please.
All right. Thanks.
Chairman, are we in a position now to have statements from the people?
Have the two of you had an opportunity to complete the file review?
It's an employee, yes, employee application.
And please speak into the microphone so that the caller can hear also.
I don't know if, are you still looking at the file? Oh, okay. Yeah, we're ready go ahead, proceed with the statements.
James, make sure you speak into the microphone.
Yes, ma'am.
Applied as a registered employee with the state of Tennessee, but it's been rejected based on your criminal history, which you have a conviction for armed robbery.
Yes, ma'am.
And that's the purpose for your appearance here today, is to explain to the board about your actions.
Yes.
What do you have to say for yourself?
Well, being that was probably 30-something years ago, obviously, you know, when I filled out the application, I thought it was standard with the rest of the applications for employment with Comcast, that anything from 8 to 10 years was what they were looking for. Obviously, this being 30-something years old, I was just under the wrong impression and didn't think that applied, period.
Okay, so I think from looking at this, you served about 8 years, and then you released on good time.
It was between 6 and 7 years, yes, ma'am.
Okay. Any other criminal history? Okay. I have questions for Mr. James.
30 years is a long time. What have you
Mighty
been doing
long.
in the meantime, Mr. James?
It's being productive.
Well, that's encouraging.
And paying taxes.
That's something that we don't have a whole lot of option on generally. What, you've been engaged in, what you've been employed with other people in the meantime?
Yes, sir. My family owned a car dealership for almost 30 years, and I've worked in the car business as far as traveling all around the country for a company called Reynolds and Reynolds out of Dayton, Ohio, training dealership people on the software that generates all of their work orders, parts and ordering integration and stuff like that. As well as some dealerships in the Chattanooga area as well. So that's basically my strong suit and my background. But being in the customer service part of it is what brought me to Comcast in the sales and customer service area.
You have your supervisor here with you.
Yes.
What sort of activities would Mr. James be involved with?
Mr. James is actually one of our presidential club nomination, our winners over the last couple of years for the entire Big South. He's one of our top sales performers. I wrote him a letter of recommendation to go over all the different guidelines that he's done.
Pass them around if you have enough.
Yes, I have multiple copies for you.
Can they not?
There you go.
Pass them out.
Yeah, he's one of my top guys. I mean,
But he's a top guy. What does he do?
he does direct sales. He sells cable to our customers, door-to-door sales, and with our MDU properties, which is our apartment complexes. So he works with a business-to-business relationship and an individual customer relationship. And probably one of my highest acclaimed representatives that I have.
You've got to understand, Mr. James. See, we don't have any of that information, and
I understand.
We're being called upon to make a decision as to your suitability in the alarm business in the state of Tennessee.
Sure.
And obviously, we would like to have enough information to base some sort of reasonable conclusion on that.
Right.
So I'm just trying to so you understand the reason we're asking these questions
Absolutely.
is to help us better understand.
Yes. What you have there are some letters of how long somebody has known me, what kind of dealings I've had with them. One of the letters is from Mr. Bob McCamey, who was the first Toyota dealership in the state of Tennessee, and he's been a national representative for some of the car dealership business. Bob McCamey is one of my personal friends, and I used to work with him at the Lexus. And
Just forgot to sign it, though, didn't you?
yes, that's because his secretary and he got that put together, and I didn't have time this morning to swing by his house. He was asleep. And then the other one is from the Lupton Company. Jack Lupton, the guy who used to own the Coca-Cola bottling company in Chattanooga and sold it, and has the honors, and they have the Lupton Foundation that does a lot of charitable contributions to build things in Chattanooga for, I guess, entertainment and tourism. The aquarium, a lot of the Lupton Company money is in it, as well as some of the other features and sites in Chattanooga. So both of those people are customers of mine. Some of them are friends of mine. So they were nice enough to write me something.
You've actually been involved in direct sales and direct customer relations for a long time then.
Well, working at the dealerships, yes, absolutely. In the service drive, in the service department, absolutely. One-on-one relationships with tons of customers. And now door-to-door sales for almost 6 years with the Comcast Corporation.
Includes the Comcast security systems.
Yes, we sell all 4 products at Comcast now, the internet, phone, home video, and now they've been into the security business for probably closer to 3 years, going on 3 years.
Forget you have someone on the phone too. So. Qualifying agents on the phone if you have any questions.
I've got no questions at this point. First of all, I want to thank the board for allowing me to join this conference by phone. I do travel extensively for work, so again, thank you for allowing this, for me to join by phone. I've met with Mr. James several times. I believe I would not be here on the phone if I did not believe Mr. James was worthy of registration with the state of Tennessee.
Lou, would
Thank
you
you.
state your name for the record?
Lou Richard. I'm the designated qualifying agent for Comcast Broadband Security out of Chattanooga.
Thank you.
Thank you.
Chairman, I don't have any more questions.
Y'all have any questions for anybody else?
Did you go, Mr. Harrison, did you go by Andy as well?
Yes, I do.
I might ought to recuse myself. I know Andy just from doing Christmas lights. He's on a lot of.
Oh, you do? Oh, that's awesome. Well, don't tell them about it till afterwards, so, because, yeah, a lot of people know me from that. Yep. Yeah. Yeah, that's one of the things that I do for charity in the community. So.
I don't believe you have to recuse yourself because you
Know him? Or,
No.
okay. I mean, I don't have that much. I've met Mr. Harrison before and do know him as a friend, but as long as that's all right, I don't have any problem with that. Yeah, I don't have anything to do with Mr. James.
Okay. Does
So I
one
think what we're saying is that this individual, Mr. James, has made application to be a registered employee. He's going to be going in and out of homes, selling or?
Yes,
or
ma'am.
whatever
He will
it is.
just be selling, no installation.
I think, I have one question. When the incident occurred back in the early 80s, exactly what was your role?
I was in a car with the other person.
Out of the car? Were you driving the car? I mean,
I
what
was
was your role?
I was driving a car. Yes, ma'am.
So when he came out of the jewelry store and you drove off, you knew what had taken place?
Yes, ma'am.
And were you armed?
No, ma'am. No, ma'am.
The board does hear a lot of things related to criminal history. I guess because of alarms, it's that this particular type of offense is more concerning. Has been a long time.
Well, obviously, you can do the math. It's been quite a long time. Quite a long time.
How old were you at that time?
I was probably 20 or 21, and I'm 56.
I would add that, out of all my employees that I've gone through the whole security process with, this is the one that shocked me the most, because he's been such, the top employee out of everybody.
Does he just market, sell, or does he actually do installations?
No, ma'am. Actually, he has nothing to do from the point of the contract or putting the security code in or getting the customers' passwords or anything. All they do is schedule the appointments, the initial sale. That's it. From there on, everything is done through the actual technician. The licensing, the actual putting in the passwords, setting everything up, doing the install with it. All that's done by the technician. Even the contract's filled out by the technician. So the sales rep does nothing but initiate their original appointment to schedule the install.
Do you just remotely download the software and the password and all that, or do you have to do it on site?
The technician does it on site, yes.
In my opinion, that process of selling home security is no different than selling cable and it sitting next to you at your house and calling in an order. So that's basically all that process is.
But we don't have any control over cable TV sales.
I understand. I understand.
Concerned with alarms.
I know. I'm just saying the process of me
No, I
putting in the
understand,
order is
but
exactly the same.
We don't have any control over
Okay.
cable TV sales.
Madam Chairman, first of all, to give full disclosure, I've known Lou Richard, the QA here, for many years. He's a former employee and a good friend, but I've never met Mr. James here before. I feel like that sufficient time has elapsed. Mr. James has presented himself in a good fashion. The recommendation of his co-workers, supervisors, and qualified agent are sufficient, especially in consideration of the 30 years that's elapsed. I know that over a period of 30 years, many attitudes change and people change, and positively, and in some cases negatively. But I feel like sufficient time has elapsed. Mr. James has served the necessary time. He was sentenced to. His record's been cleaned since then. So I feel like that it would be appropriate for the alarm board to grant his registration, and so I would move that we do so.
Okay, we have a motion by Mr. Roberts to approve Mr. James's employee registration application. Do we have a second?
I'll second.
Okay, we have a motion and a second. All in favor, voice by saying aye. Aye. All opposed?
Did you say we need a?
Roll call.
Roll call, sorry.
Well, council doesn't seem to think that we do.
Well, we
need
don't have a
roll
board member on the phone. We have the board
That's right.
member here, so.
All right, so this is.
So the
your
motion
votes,
carries. Congratulations, you're approved.
Thank you very much.
Thank you all very much.
Thank you.
Thank you, Lou.
Be sure to show them my Christmas.
Thank you. Thank you very much, everyone. I appreciate it. Thank you.
They're located in Salty Daisy, Tennessee. It's a Christmas light show set to music. It
Been
kind
there
of
every year, just didn't know where it was,
yeah,
so thank
yeah,
you.
Yeah, it's big on the internet, of course, because not everybody can make it
No,
all the way.
I see it. I see
Awesome.
it, yes.
Awesome. Well, thank
But I
you all
didn't know
very
that was
much.
you, but thank you very much.
They keep the others.
Yeah, let them keep.
You want your,
No, we'll keep them for the phone. If they're reference letters, we need to put them in the phone.
That's fine.
Thank you.
Thank you very much.
here you go. They're copies.
About 8 employees on all your stuff.
Do we have any more appearances present at this time?
Don't have any more.
Anybody else scheduled?
Okay.
Well, that's just like that said, we just have about what, 7 or 8 employees, and then just a few things that I have. Do you want to break for lunch, or do you want to work through lunch? Just break for a few minutes.
All in lunch, or we're gonna go to
No,
the
we,
break room, or what?
We just break for, do you anticipate any substantial period of time involved?
we're probably looking at another hour or two.
I think I'd rather have a break for lunch, because I'm not a breakfast person. Is that okay with the board?
Okay with me? All right.
Do you want me to pull up Jimmy John's and see if we can order some sandwiches and have them
That'd be fine.
delivered?
Well, I think that's kind of late, isn't it? 12 o'clock?
Well, they'll still deliver them.
Can we go to the market?
Yeah.
Yeah, you can
Yeah,
go.
I'll tell you
walk
what,
over there.
we're gonna take an hour recess.
Okay.
They would walk over to the farmer's market.
Yeah.
Does that mean we're ready? Okay. I'd like to order this meeting of the Alarm Systems Contractors Board. And next on our agenda, Ms. Best, is your administrative report.
Yes, thank you. We're going to go to Exhibit B. Is your open complaint report? It says on the outside 55 complaints, and then Attorney Kilgore presented 28 today, so that leaves a total of 27. This is a report that it probably looks a little different to you. Hannah is in Egypt. She prepares this information, so Beth's been kind enough to step into her shoes while she's out. So we thought we just wouldn't reinvent the wheel, just give you the reports as we get them. The different codes on there, and stop and ask me questions if you'd like, if you see anything. We can go to Exhibit C, which is the disciplinary action report. We were talking about that list a little bit earlier this morning. For our new board member, as you see, we regulate several programs, and it has all of the programs that we regulate, but we're just concerned with the alarm board here. So it looks like in March, the civil penalties or disciplinary was $500, in April was $700, and in May you had $9,950. And this was a question our new board member had asked about the civil penalties. And some months, yes, we do. Other months, we don't. It's according to the complaints as they're filed. But May was the big month there. I think my pen's running out. Then you have the monthly report, and this is the one that we send out in advance to you because it is so big. The biggest thing to notate on there every month is that there's one board member whose term expired, which now has been filled. Ms. I'm sorry, Scott. Okay, and like I said, we did want to thank our previous member. And we have one other member who is going to expire this year too, if I'm not mistaken. That's our chair, Vivian Hickson. So that's not on there. Now, you can just take this with you. It's the same, basically the same information that you've just seen in the other reports.
Just Scott, for your information, I generally email these out when I finish them every month, so you'll start getting this.
Yeah.
And the
You'll get
disciplinary reports too.
Say we could take these with us?
Oh, yes, uh-huh.
The iPads?
No, you don't have an iPad. You can't take the iPad. Okay, then you cannot take it. We can email it to you. A little tricky there, uh-huh. Okay.
I ought to be nicer than that.
That's
I
all right.
apologize.
That's all right. Well, let's go to what we call the E exhibit. You should have E 1 and 2. Pardon me. It's legislative update information. As we get information, we like to bring it to you so you know what is going on in our office and with the industries. The first one here is Exhibit E1. It is Public Chapter 815. It's Restoration of Citizenship. It has passed. I have a section here that says, let's see, here's Section 1. Down to M1. If a person presents a valid certificate of employability, no board, agency, or commission or other licensing entity that issues, restores, or renews licenses or certificates and regulates occupation and trades for which a license or certificate is required to do business in this state shall deny the issuance, restoration, or renewal of an occupational license or certificate based solely on the person's past record of criminal activity, but instead should be considered on a case-by-case basis whether to grant or to deny the issuance, restoration, or renewal of an occupational license or an employment opportunity. We see a lot of criminal records in our office. I don't see these restoration of rights very much in the alarm industry. We usually see them in the PIs.
But Cody, I read through that pretty carefully, and I think that we, of course, when we, just like Mr. James, who was here earlier, we consider each one on a case-by-case basis. So I can see where that law would be especially applicable in some other areas, but I think we very satisfactorily meet all the requirements of it.
Glad to hear that. We do. We think the same thing. But I wanted to make sure everybody knew that. And if you want a copy of it, we'll be glad to. You already emailed it. Good. She said, did you email it to Scott?
I got it. Yeah.
Okay. Good. Good.
He's on the list, man.
All right.
I sent this one
Hey,
to him
Scott,
yesterday.
you're on somebody's list.
Yeah. That's scary.
It doesn't start with an S. It's okay.
Okay. The second is Exhibit E2. This is a little bit different. This is your Public Chapter 881. I'm just going to scan this a little bit. I'm going to tell you that the administration is working on this chapter here. They are preparing perhaps standard language for all the boards to use. They don't want me to get too involved in this today. You'll be meeting in September, I think it is. Isn't it September? June, July, in September. Hopefully we'll have the forms and more information to update you on this. But what this is, it says here, the boards and commissions created in this title in consultation with the Division of Regulatory Boards shall develop a plan to create an apprenticeship program used for such boards and commissions. This may be feasible in some programs and may not be feasible in others. That is what we are looking at. We already have an apprenticeship in the locksmiths, and private investigators, and then polygraph.
Cody, the Electronic Security Association also has an apprenticeship program that's available to people who want to become a part of the industry, and it's been available for maybe a year now, but and it hasn't been very widely utilized yet. but there is an apprenticeship, a full apprenticeship program that's available to people who want to become members of the Electronic Security Association, or not the association, but the industry.
So that helps them get a license?
Yeah.
Okay.
Yeah, it's an apprenticeship program. Just like any of the other apprenticeship programs, you go into it and there's training involved, and as on-the-job training, there are courses that are part of the program. It's a full apprenticeship program that ESA has. If you need some more information on that, Penny could probably get that to you most
we probably
directly.
need to get with Penny on that, because I want to know.
I didn't know whether anybody was aware of that.
No, I was
but
not aware of that.
It's been available a year, maybe a little bit longer, something like that.
Okay.
In some states, it's very widely accepted, especially with the union programs. Apparently, states that have strong unionization have been using it pretty extensively. It's very, very widely utilized out in California, from what I understand. TJ Lowndes is the one that has been most directly involved with that, but Penny would have the particulars on it.
Yeah, we'll get with her then, or I'll get Beth to get with her, and then administration will want to know that before they go fixing up anything for the alarm board. Okay, so I have on the next, I might be out of order.
E3.
I'm at E3, okay. We're on E3, Contractors Board rule changes. This is just for your knowledge, for you know what's going on in the Contractors Board. They did, under their the CE license, they did add the Tennessee Alarm Contractors Board may require a license. Yeah, but, yeah. And on the other one, on the other page, if you saw that.
Got it on your iPad.
Yeah, on the iPads. Fire detection systems, singles and burglar alarm systems, and security systems with conduct and wiring above 70 volts requires an electrical exam.
They didn't change that one.
They did not change that section. They just changed the D section, the D, but it added the Tennessee Alarm Contractors Board. They're just saying you may also need to get an alarm license. We've been asking that for a long time.
Well, we wanted them to take that out of their rules, but they
But
haven't.
at least we got that much in there. All right. Now I think what we have there now is my budget update. It's, as you can see, which is Exhibit F, excuse me. It's got, the latest that I have is April. And that's, the first sheet just gives the expenditures. Your second sheet gives your total of the monies that we've taken in for the year. That does not take into consideration any cost backs. Your cost backs, of course, are going to be your formal hearings, your attorneys, investigations, things of that nature. All programs are going to have to help pay for the new computer that's going on. I tell you about that every time we meet. It's core. Beth and I have been in extensive meetings to try to help get all this corrected when we get onto the new system. So this program will be paying its share of that as well. The only big thing for you, and I think I mentioned it the last time, would be September was at $20,000, and that was where we paid for the exams. The exam rewrites. I review this every month to see if there's any changes on it, anything that looks odd. The above part where it says payroll expenditures, of course, we cannot touch that. That's already set. So basically, the only thing Beth and I can do in the office is hold down supplies. And we do share that between all the programs.
Sharpen the pencils less
That's about
frequently
it.
so you don't wear them out.
It works.
Right, and so right now, if you want to, we'll go to Exhibit G, which is correspondence review, G1. This is AT&T Digital Life, company number 1792. They're asking for a second extension to replace their qualifying agent. They lost their agent in January. We granted in the office, of course, the first extension. They have to come before you to be granted the second extension.
They have an applicant on file, and she's scheduled to take the test at the end of the month. She's already sent in her training, Everything's here except for her exam score.
Madam Chairman, I make a motion that we grant the 90-day extension, isn't it?
Second, second.
The second 90-day extension to AT&T Digital Life for their, give them an opportunity to replace their DQA.
We have a motion by Mr. Roberts. Do we have a second to permit them a second 90-day or a 90-day extension, second request? We have a motion and a second. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Okay, on the next one is your G2, it's from Power Home Technologies, number 1514. They also are asking for a second extension. They lost their qualifying agent in January as well.
This one's a little bit different.
They do have someone else they're trying to put in there, and as their qualifying agent, he's scheduled to take the exam this month.
He's taking the training in CCTV. See, he's only applied in Bergen Fire. So what they're asking for now is an extension to keep CCTV on their license for 90 days while he tries to qualify for it. They lost their qualifier. They have a new applicant who's about ready to issue in Bergen Fire, but he hadn't even applied in CCTV. Normally, under those circumstances, we would tell the company they have to drop CCTV off their license, and they can add it back when he gets it. But they've asked for you to consider giving them an extension in that one classification.
What happens to the contracts if they drop the CCTV from the license?
They can't service them, they can't do anything.
That's what I thought, so.
That was a little bit different.
Excuse me.
So he's going to take his CCTV test.
He's doing
this
the
month.
training. I think Howard had a class last week, and the ESA has one here in Nashville in July. I don't know which one he's planning to take, but he thinks he can get that and get the exam in the 90-day extension if we allow him to leave it on their license.
Madam Chairman, I make a motion that we allow the second 90-day extension to Power Home Technologies so that they can have an opportunity to replace their DQA.
I'll second that.
They're going, in the motion there, can you also state whether they can continue with the CCTV on their license?
Yes, and so that they can continue with the CCTV that they are currently serving on their license.
We have a motion and a second to grant this company, Power Homes Technologies, a second extension for a DQA to be licensed, but to allow the company to continue with their CCTV business. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Go to G3. This company is also asking for a second extension to replace their qualifying agent, Security 2000 LLC, license number is 0761. They lost their qualifying agent when Fred Sanford passed away.
His son Freddie's decided to go ahead and apply. He's got the 5 years, but he's going to have to get his training and pass the test.
Madam Chairman, I make a motion we grant this 90-day extension so that they can have an opportunity to replace their DQA.
Okay. We have a motion. Do we have a second in this matter?
Second.
We have a motion and a second to extend a second extension for DQA.
Their attorney submitted that letter.
Security 2000 LLC. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
I believe the last one on this is G4, Stanley Security Solutions, number 0235. They're asking for a second extension to replace their designated qualifying agent. Go ahead.
Henderson was presented at the last board meeting and his experience was denied. So they have to get a new applicant.
They have to get a new applicant. They might go over this 90 days.
They're already well into it at
Yes.
this point. If they
I'll help you
expired,
look at-
current first extension expired on May 1st. They're already a month and a half into their 90-day extension if we grant it. But and I think we should. So, Madam Chairman, I'll make a motion we grant a 90-day extension to secure DQA to Stanley Security Solutions.
Second.
Okay, we have a motion and a second to grant a second 90-day extension to
Stanley Security Solutions.
Solutions. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Are they out of Georgia, the company, or is that just their headquarter
That would be,
letterhead?
I think 235 is their Memphis office. Their home, one of their corporate offices, they've got 4 different divisions. That came from their corporate office in Georgia, but the office we're looking to replace a QA for is the Memphis office.
Okay, the next thing on the agenda was H, was appearances, and we already did the appearance this morning at 11 o'clock. Sir, did you find out anything?
My boss asked me, somebody tried.
Okay.
Please, I'm so
Could we just take just a 2-minute break for just a moment? So we,
I'm so sorry.
You want more than 2?
no, that's all we,
We're back at it.
yeah. You got that turned off?
We're going to take a break. Okay. Call the meeting back to order. I think Exhibit I-1 is our first.
Right,
Is that
uh-huh.
correct?
It's your qualifying agent, Mr. Gregory Burns. We want to review, or you're going to review his training.
Can I explain something on this one?
Yes.
I've had some of these documents from this company for over a year, and I kept telling them we didn't generally review stuff like this without an application on file. We finally got the application. For what they want you to do is approve the training he took in Virginia to meet the training here. Some of it appears to be from the transcript they sent. It looks like he completed level 1, electronic security, through the Virginia Burglar and Fire Alarm Association in '05. And then it looks like he took entry level electronic security technician in '97. And then he took the sales representative, and he went through the Virginia Department of Criminal Justice Services training. The only thing I see here that you could even remotely accept is that transcript that looks like it is the equivalent of certified alarm technician. He's still going to have the CCTV training, and I don't see anything else in CCTV other than a 4-hour J learning course. Got lots of licenses. He's got training and exams he had to take in other states, but it shouldn't waive our examination or any of our other requirements. The only thing I see as an equivalent out of this whole packet is the transcript from Virginia showing he completed what appears to be certified alarm technician. And he has a little weird certificate at the very back that says certified. I don't know if it's in here. It might be in his file. There's one little piece of paper but it's not like a certificate of completion. He's the president of the company, so. He's been licensed in North Carolina since 2002, and he's been licensed in Virginia since sometime in the late 90s. In Virginia, that you have to go through their training. They won't accept anybody else's. You have to go to one of their approved facilities to get your training.
Virginia operates under their own set of rules and regulations, and they don't like cooperating with anybody else, but in my experience. The question we're faced with here, and correct me if I'm wrong, is he is looking for enough experience to get his QA license.
Well, I'm not worried about the experience. He's got plenty of experience.
Okay.
He's looking for the
Education.
burglar alarm training. Yeah.
I don't see it in the information that's presented here. Now, as far as the basic course, yeah, I can buy into that. But the advanced courses that would be necessary to be a qualifying agent, I do not see that demonstrated here. It looks like he's taken a number of entry-level courses.
And a lot of sales courses.
And sales courses.
The one that I thought would qualify or might, if you look in 97, he did the entry level, but then in 2005, he took the electronic security technician course through the Virginia Burglar and Fire Alarm Association. And I believe that's level 1.
That would be basically a level 1.
Which is all they have to have to qualify in Tennessee is level 1.
Except for qualifying agent.
Certified alarm technician. That's all they have to qualify in Berg. He's still gonna have to have CCTV training, but that's the only thing I saw that might even be applicable.
Madam Chairman, I make a motion that we notify Mr. Gregory Burns that we do not see sufficient evidence of his training to grant his qualifying agent license at this point.
Okay. We have a motion by.
The request.
Okay, we have a motion and a second based on the documentation presented to us that Mr. Burns does not meet the qualification for his qualifying agents. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, let's go to I-2, qualifying agent for Cody Carlton. He wants you to review the experience. He's going to be with Walden Security, which is making an application. He has been with Security and Communications Cabling. And let's see, several sheets back, you will see his list from, he wanted us to review, where he pieced together some dates enough to get his time in. You can see from, yeah.
Got fined $50 times 10 months.
It's 500.
500.
I can remember something.
Because I was asking, was he trying to get 5 years out of 10 months?
This is
You
the
need to
same.
look at all the pages.
I am. I'm just asking the same one.
I think, based on my memory of that complaint, was he had 4 years of registered experience. I think he's just trying to piece together 1 year out of the time that he wasn't registered. But in my recommendation also,
Sorry, what did you say? I was having trouble getting my
that's
buttons
okay.
pushed.
Based on my memory of the complaint, I think that he had 4 years of registered experience, and he was trying to get the last year of experience based on the other time when he wasn't registered. I think that the 10-month recommendation came from giving him the benefit of the doubt that if he had been registered within the 30 days, working days, so that's how we got to the 10 months unregistered. Don't you think he has enough?
Again, if you look at
He
his
has, like,
employee
over 8 years.
registration application, which is his back page, we initially got his employee registration application April the 23rd of 2010, and it shows a hire date of 3/15/2010, which would be 4 years. And then we just fined the company for working him for 10 months without being registered, so and with the other part-time stuff, it could essentially be, but I again, we can't approve it in-house. It had to be y'all's call, so.
Separate companies, same gentleman.
He's applied,
Signed under one company, but he's applying
He's
under a different
trying,
company.
Walden Security has a application, and this gentleman here is trying to qualify to be the QA for Walden Security. So I think it
We're
is.
trying to get into burglary and security.
they're getting cameras, and they're gonna be monitoring them, and they're gonna be doing Berg and cameras and monitoring. What we think they're doing, and based on what I've talked to them about, is a lot of the mall security where they already have security guards on staff, they're gonna be putting in cameras and probably some kind of access stuff, and monitoring them from their facility in Chattanooga, similar to what RMC and some of the other guard companies are already doing. He's got to apply on all three. He only applied in monitoring. He's gonna have to add Berg and CCTV after we've had these conversations, so he's gonna have to have the training in all three and pass the exams in all three.
Main thing that we're looking at on this is strictly the
Experience.
experience time.
Boils down to, are we going to accept him with 5 years, as having 5 years' experience or not?
It sounds to me like he has that. If we earlier were basing the,
Signed in for 10 months.
right, the finding there for 10 months, and then he's been a registered employee for 4 years or nearly 4 years.
Actually, at the time of application, he had 4 years and 1 month. At this time, he has almost 4 and a half, so 4 and 4.
Would make a motion then that we approve, we're approving his application? With
Experience only.
Experience.
I'll second the motion.
Okay, we have a motion and a second to approve his experience as listed for Mr. Carlton for his qualifying agent application. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Drop down to Exhibit I. No, here's I3, I'm sorry. I3. I can't even read my own stuff. Qualifying agent, this is for the exam score.
This gentleman took the exam in October of 2008 and applied for his license in May of 2014. But he never applied before. There were some other involved things that somebody dropped the ball somewhere, but he's applied now. And he wants us to accept his exam score from 2008, and the only thing he's applying in is monitoring. He's with a central station in Houston that only monitors their own company's accounts. And I told him I couldn't accept it just because it was from '08 and he didn't have an application on file at the time.
Have any reason that we wouldn't take?
Not really.
If it's, I mean, if it's.
They have a guideline, but they don't have a law or a rule, correct?
With some programs, you know, it's 2 years or a year or whatever. This one's just a little outside the scope of anything. This exam was offered by a different company at the time, but it's relatively the same reference books, the same training.
Is he in the monitoring?
He's the manager of the central station. He only manages the central station in Houston, and they only monitor the accounts for their company here in Tennessee.
This is a new exam. We just did the new
Yeah.
exam with the new company.
I mean, again, it
Last meeting, we didn't accept one that was over, I think it was 6 months.
I think we did, because I
We
remember
did.
Mr. Roberts saying, once you've taken the exam, you've always
no,
taken
it was the
exam.
training.
Oh,
It
the
was his training.
It was a training.
It was
Training? Okay.
NPS level 1 from 1997 or 98.
Oh, okay.
We had previously sort of taken the position that once they've had the training, they've had the training. It may be out of date in terms of modern application, but we've not tried to establish dates. And I would almost feel like the same thing would be reasonably appropriate with the exam, and given these particular circumstances. As you've outlined, he's taken the exam and passed it. It's not the current exam, but he took the exam then and passed it. He looks after their monitoring. He's probably been doing that for a long, long period of time. I personally would be willing to accept this, and so I make a motion that we accept his examination as meeting the necessary requirements for the monitoring qualifying agent.
We have a motion and a second to accept his documentation for the exam and test score for his qualifying agent and monitoring. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, that finishes Exhibit I, so now we're going to go to J, which is alarm employee application reviews.
You got
They're in hard copy.
I was running on short change yesterday afternoon, so these are printed, and there's only 8 of them, so it won't take long. You don't lose those clips.
Yes, we have to turn the clips back in.
You notice,
You recycle them.
That's right, but you have to
have you
turn those
noticed
back
they're
in to me,
serial
too.
numbered?
When I
Yes.
said jumbo,
They
I just
are.
meant a lot of material. Was mine.
They do, we have to send them back to the cashier's office.
So they can send them back to us. Here's this one.
11th floor.
Did you bring that stuff in? Back from your truck?
I have,
Okay. And don't forget to leave without signing your travel stuff too, which is right here.
Okay, we'll
oh, I don't
go,
have to rush home. I'll get everything done.
we'll go to Exhibit J, we'll go to Exhibit J1, I'm gonna get this done a little bit different here. This individual We do have a written explanation, did provide, info was provided by the applicant, that the criminal history that you're gonna be seeing. We do have a letter from the qualifying agent. The second sheet we've enclosed, it tells you what he disclosed on his application and what might be on the criminal record.
First of all, I don't see any numbers on this.
There, alarm contractor license number there at the bottom.
Wait a minute, there should be 2 letters.
Well, the last one doesn't have a number on it.
There's not on either one of them.
Oh,
Letter of warning, huh? But we do, I think it was, a long time ago. No, it was a long time ago.
It was an automatic $100 fine
Yes,
a long time
a
ago.
long time ago. Now we do the letter of warning.
and I think a letter of warning's a lot more appropriate for somebody that makes a simple mistake like that than makes necessary actions to correct it.
I just
Simple possession is still listed in your statute as an offense. Or just possession.
How long has he been employed by the company?
Most of these applications have
These
been
are-
here a
this is-
while, so.
Well, yeah, but it's a brand new application. When you say it, it's old.
October of 2013.
Oh, okay.
Looked like you waited for his 11/29 to run out for
Run
you.
out before we couldn't get
His
him
employment
probation.
date was 9/23/13. We got the application October the 11th of 2013. And it probably should have been on the agenda for the March meeting, but we had so many, I don't think I got them all worked in time, so. They're in Garner, North Carolina. They work out of the Johnson City area. They do the door-to-door sales just like all these other companies. I'm surprised they haven't knocked on your door, Karen.
Madam Chairman, I make a motion that we grant this application for a I think also we need to file a complaint for not having the contractor's number on the letterheads.
a registered employee.
Yeah.
All these are.
The next one is JE.
Was there a
We didn't-
second?
we didn't vote.
I
I'm
don't-
sorry.
That's okay, that's.
I don't, didn't
Do we
hear a
have
second.
We have a
Nobody's
motion
wanted to
by
second
Mr.
it yet.
Roberts.
Oh, okay, I'm sorry.
Do we have a second?
I'll second it.
Okay. We have a
I was just
motion and a
thinking about
second
the
to approve
2011.
J1's employee application. All in favor, voice by saying aye.
Aye.
All opposed? Okay, now you can go to 2. That's okay.
heard, or didn't hear. All right, the exhibit is J2. You also have a written explanation that the individual did supply the court documents, and there is no letter from the qualifying agent. And this is probably Comcast.
It is.
They don't provide the letters.
Well, Lou will write one every now and then, but the Robertson won't, so. I think they wrote y'all one letter and said that they would leave it up to the board's discretion, so. This person is employed by Comcast and his hire date was 9/23/13 and we got the application October 17th of 2013.
Exhibit J2.
We have a motion, do we have a second?
Second.
Okay, we have a motion and a second to approve Exhibit J2's registered employee application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we'll go to J3. This individual also with Comcast, you have a written explanation and court documents and OQA letter.
I have this stack of criminal records. It looks like a complete transcript. I think there's enough in there so y'all can see the final outcome. It took me about half an hour just to get through here to try to figure out what it all was. But it's all certified copies. They did send in the court records with this after I asked for them.
A lot of the time that's passed and the charges most all dropped because his friends told the truth.
Second.
We have a motion and second to accept Exhibit J3's registered employee application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Okay, we'll go to J4. We have a written explanation and also court documents, and we do have a letter from the qualifying agent.
I do have two of them. This might all be in here twice.
Residential burglary.
I think it got copied twice. Sorry. And yeah, now I got disposition codes.
Well, perhaps that's just the letter that he wrote. I
Yes.
thought it was from the qualifying agent for Section 1.
It's getting harder and harder to get those. We have to ask for them. Yeah, it's just twice. You got the whole thing twice.
Do they list all of the charges on the application? Because it looks like there's stuff that's not on the.
Well, a lot of times they'll list something on their app and then attach documentation of something else. So we kind of consider that as disclosing it. And then the one case that he listed in 03, there were like, sometimes there's 2 or 3 charges on the same date too, and they only list what they're convicted of. That happens a lot. Yeah, they sent the disposition codes with that one showing what it meant. Really, the only thing I think he has is a possession conviction with 18 months probation, 15 days jail. Maybe he has 2 of them, one in Dallas and one in Arlington, Texas.
Was there any information on the burglary?
They didn't file charges against him, but since he disclosed it and put the dispo in there, I put a copy of the thing where it says no case filed.
Okay.
They didn't charge him with it.
Madam Chairman, I make a motion that we grant Mr. Jackson's application.
Okay, we have a motion to accept J4's application. Do we have a second?
Second.
We have a motion and a second. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. I think we're ready for J5.
Okay. We have this one here. Look like we have a written explanation and court documents. It's, but I did not see a letter from the qualifying agent. Oh, no.
This guy was kind of different. He disclosed a misdemeanor. That's exactly what he disclosed, a misdemeanor. And then he provided court records, and I got an explanation from him in April, so. Maybe because if it's on this dispo, it says Class A misdemeanor, so that's what he put, A misdemeanor.
We don't have no letter from the QA.
No, they don't send it with it, and, you know,
Actually convicted of felony aggravated assault.
it looks like A misdemeanor assault, doesn't
Says he was,
it? It was reduced.
I was convicted of third-degree felony assault, aggravated assault. They lowered it to a misdemeanor, which, it's strange.
I think he's the one that was at some restaurant or, yeah.
Mm-hmm.
It's even worse volunteer at the church. Good Lord.
Madam Chairman, I make a motion that we grant Mr. Johnson's application for as registered employee.
Okay, we have a motion, do we have a second?
Second.
We have a motion and a second to grant Exhibit J5's employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, we'll move to J6. You do have a written explanation of court documents and no QA letter because he works for Comcast. The next two are Comcast. Big car.
Madam Chairman, I make a motion we grant this Mr. June's application as a registered employee.
Second.
Okay, we have a motion and a second to approve Exhibit J6's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, we're going to go to J7. You have the written explanation there and the court documents as well.
It said more than 50 and less than 2,000, didn't it?
Oh, yeah.
Oh,
Less than 2,000 and more than 50. Or,
pounds?
uh-huh. Read her explanation. This one's a little different.
Driving his car, and she was a passenger.
Just based on her explanation, that's what it looks like.
Yeah, they getting ready to leave and got a flat tire and keep on driving.
Plus, she got deferred.
She was on probation for what, 4 years?
Yeah, but she was on deferred, so
So we cannot consider that.
I don't really think that that's the same as conviction.
Well, if it was expunged, it wouldn't still be on her record, correct?
If it was expunged, but.
For the adjudication,
Punishment in here.
Not in the indication it's been expunged.
Get one
there's
in.
not. It does say 12209, deferred probation 4-year, fine $4,000.
Heavy for a simple possession.
Wasn't anything simple about it. It said
It was over 50 pounds.
it was over 50 pounds. It said less than 2,000 and more than 50 pounds, so. Which is why it was considered a felony and. They didn't have those new compartments set up back then where you could put it in your wheel well and put the tire over it. That's a new thing.
Amazing what she knows, isn't it?
I watched it on the news last week.
I'm wondering, experience? Did
They
you
were
have a
showing, no, how these people are mules coming in with all these drugs and how they're, it's amazing. Yeah, I know a lot of stuff. I watch the news a lot.
Motion on this.
Yeah. That's one of those. She is also a sales rep going into people's homes selling cable, I guess, and alarms.
If we were to deny the application, she has a chance to come before us and
She does. She does.
Okay,
I don't think,
okay, wait a minute.
yeah, that's what Josh was fixing to.
I'm not sure that there's anything to deny her on based on the fact that she's completed the terms of her deferred adjudication when she was placed on probation and paid the $4,000 and didn't get in trouble for those 4 years apparently.
would that also tend to suggest that maybe the courts did not see her as involved? I mean, we're taking her word here, but if
Well, I
the
think that-
finding from the court also kind of suggests that, so I'd feel better about it, I guess.
Well, I think the fact that they put her on probation at all rather than convicting her flat out of the felony for possession of over 50 pounds of marijuana seems like the court didn't feel that she was as culpable as the boyfriend. I believe so. I mean, that's the way it works in Tennessee. I think you're only eligible for that one time, essentially.
That's what I would
Before that.
expect typically, that they, if they felt like she probably did.
I make a motion we accept and do it J7 for the registration.
second that.
We have a motion and a second to accept Exhibit J8 for employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Okay, the last one is J8. You have written explanation, you have some court documents, and you do have a letter from the qualifying agent.
He works at the central station in Knoxville for ADT, so he's a monitoring employee.
You got judicial diversion.
I'd like to point out that this applicant is on diversion as well, but you'll note that he has not completed the terms of that diversion yet, and not till January of 15. That makes it a little bit different situation.
What was the company's license number again?
I don't know. Actually, the company ID is 1695.
I was just looking for it on their letterhead.
It's underneath her signature. Got her license number and the company license number.
Is it on the ADT letterhead?
Yeah.
It's not part of the letterhead. Look at her signature.
Yeah, signature.
Ronald P. Williams.
I was looking at the first
No.
letter.
There's nothing on this. It's just got ADT and nothing
Well,
else.
that's his explanation. The letter from the QA has it on her signature.
Has it one letter down? The Q.
Just picked up pieces of their letterhead and wrote it himself, his written explanation.
This looks like generic ADT letterhead. There's not an address or anything. Right.
Looks like he's responding there too in almost a personal, I guess he's got his title down and it's from ADT, but
That's his
given his
explanation.
personal response to the.
Madam Chairman, I make a motion that we grant Mr. Williams' application as a registered employee.
Even though he's still on. A8's employee registration.
Second with, addition to that notify us when he's completed his. Haven't we done that in the past?
We in the past have had the person in question give a voluntary consent to some additional conditions. I don't have a particular problem with it. For him to notify us when he satisfactorily completes his probation.
Basically be another litigation monitoring consent order like the one Ms. Ryan proposed earlier, except this would be in criminal court, not civil, but the registrant would sign that consent order and basically volunteer to give us the information.
Notification when they
Right.
complete their probation. Okay,
Usually
I
when we
would-
do them for alarms, we send it to the company, and the employee and the company qualifier both sign them.
I have a motion and a second to accept Exhibit J8, employee application registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, Madam Chair, that does complete my administrative reports.
Have y'all had time to review any of the courses I gave y'all earlier
Oh,
today?
thoroughly.
I thought you had.
I didn't take any of them, but I reviewed them all.
What about you, Scott?
I looked through a couple here. I didn't look through the
The
entire
NFPA
one.
one is pretty much a given, if you feel like sprinkler
Well, that was-
systems are applicable.
That was my only concern. It's about installing sprinklers.
I kinda had the same question, but
You want to see it, or?
If it's a sprinkler course, I don't really consider it much, very highly.
all right.
It's not about sprinkler monitoring, it's about sprinkler installation.
I've got one here that I'm not gonna recommend approval.
I wouldn't think it would apply to the alarm.
What did they put on their cover letter? They were, you've got it in front of you, they had a reason they wanted that to, and again, you have to, when you're putting in a basic alarm, do you interact at all with the sprinkler system?
To some degree, but
Like-
it's really pretty limited. And quite honestly, in most circumstances, the sprinkler company installs the monitoring devices, the flow. Basically the same thing. It's-
Yeah, I saw there was one over there for water-based sprinklers or something, or maybe this
Yeah.
one was. And again, they only submitted it for continuing ed, so if some qualifying agent took this and it's a 21-hour course, they could meet their continuing ed requirements for their license. That's all they asked for, approval for, was continuing ed. I'm not trying to convince you either way, I'm just clarifying that. You wanna start at the top of this little list that I have that y'all don't have? It's in your packets. All right, the Tennessee Electronic Security Association submitted a 1 hour, it was their West Tennessee Regional lunch meeting in April, and the speaker was a gentleman from the codes office. Did you go to that,
I did.
Scott?
Uh-huh.
Was that a good hour?
It was
They've
good.
been doing a lot of educational meetings at all the middle, at least the middle and West Tennessee.
He's doing a good job, Pat, is doing a good job.
I
getting me-
had that one to review it, and I felt like that was worth the 1 hour of continuing education that was requested. So I would recommend that we grant that for 1 hour of continuing education.
Who had the Jade Learning 4-hour introduction to network security
I had
cameras?
it doesn't seem like 4 hours to me.
They're online courses. All the Jade Learning courses are online. The board has several that are previously approved, but not one with that title, and almost all of them are 4 hours. I think they have like an exam at the end, so
Is this the whole course?
that's all they sent us.
Because there's like 1, 2, 14 slides for a PowerPoint, and then 40 questions. It's a decent course, but I wouldn't think it would be 4 hours.
Then you can recommend it only be approved for 2, or what, you know. And if they want to appeal that, they can send you more information.
I guess I would make a motion to, is that what I need to do, make a motion to approve it for 2 hours?
Why don't we do recommendations and then make one motion at the end?
Okay.
Is that okay?
Okay.
Thanks. All right, Elite CEU Alarm Level 1. This is already approved for qualifying education, and it's an online course, employee training, and for continuing education. This time they have resubmitted it because it has expired. They think it's a 27-hour course. But we currently accept it to meet the burglar alarm, qualifying agent, to meet continuing education requirements, and to meet the employee training requirement, which is the equivalent of NTS Level 1.
I have that course and looked through it. It looks like it's a pretty comprehensive course. They are requesting approval for employee training and initial application. Doesn't say anything about QA, and surprisingly enough, they didn't include continuing education. It's a very basic course, so I'm assuming that they feel like that somebody who is looking for continuing education would not be taking this particular course.
It's currently on our approved list for both, but I don't have to put it back. It's on all three of our lists.
They requested employee training and initial application. And
Would it be suitable for continuing ed even if they didn't ask for it?
Yes, I would think so.
Okay. Because as soon as I email them and tell them it was approved for that and that, she's gonna ask me about the other.
I would think it's, now this is strictly burglar alarm in each case. So I'm going to recommend that we approve it for that.
Okay. Did you have time at all to look at the video surveillance systems and closed circuit television certification course that they have put together?
This one looks like, if I'm reading it right, it's like a proctored exam. You take it online, but then
You
it's
take it all online.
they call it a. This one seems a lot more in depth than the.
Well, that's because they just submitted that one, and then there's a whole nother stack of all these little 1 and 2 hour courses that make that up.
I've
that
got
they want
that.
approved individually. And I did not list them because at 4:30 yesterday afternoon, I did not list all the small courses that make it up.
Doesn't say anything about 4:30 yesterday afternoon.
I'm
on this.
sorry.
If you'd like for me to go through those, I can, for the record, go through them if you would like.
Well, if we approve the CCTV training, and I was gonna pull those and read them into the record, but basically the reason I had them separated the way I did is because those are the courses that make up this 15-hour online segment. And I think when they came before the board several years ago, Ken, and we told them we weren't comfortable with them offering an online exam. And for us to accept it, they would have to offer some kind of a proctored exam at the end. And I think that's why
Because the problem is you don't know
who's taking the course.
who's taking it.
And to be more consistent with what ESA is doing now, where you can take the course online and go sit for a proctored exam, I think PSI is actually offering their exams. I'm not certain.
The list of courses that I have here are virtually all 1 hour courses. I think there's one exception here which is a 2 hour course, and they're all for closed circuit television. They to me, they look very reasonable for that request, and so I'm going to recommend that we approve them for that. They're requesting employee training and continuing education in the CCTV category only.
Well, those can
I'm gonna
only be
recommend
approved
it-
for continuing ed, those.
Yeah,
And
continuing
then
ed.
Scott has the comprehensive 15-hour course, which is most of the same information. But there's a proctored exam at the end, and they want that to qualify for somebody to apply in CCTV, like a qualifying agent. Which would be great because we don't have an online CCTV course right now. So anybody that wants to get their CCTV license either has to take the ESA video course or VIT, which is Howard's course. That's the only 2 courses we have. LTC, Charlie Pierce's courses haven't been updated in probably 10, 12 years.
Yeah, long time.
So we quit accepting those.
I wouldn't have a problem with these. Like I say, the coursework here looks pretty reasonable for what they're requesting.
You think that looks like a pretty comprehensive course too, Scott? All right, there were 2 or 3 other really small ones. The foam water sprinkler and spray systems for continuing ed, that was also elite for 2 hours.
I had that, and I was really not impressed with that course. It's listed for fire, but it's virtually all fire suppression and this doesn't have anything that I can find that has to do with fire alarms.
Would that have any bearing on a qualifying agent who needed 2 hours of continuing ed for renewal? Would that be applicable for that individual if they did fire systems? Just in question. Because that's all that I've got on my list is that they submitted it for continuing ed only.
They're requesting it for employee training and continuing education 2 hours.
We wouldn't ever include employee training under a 2 hour. It has to be at least a 15, 16-hour course.
Yeah. So for continuing education, 2 hours on foam fire suppression. Really pretty iffy.
I mean, you don't have to approve it, or you can say it's only good for 1 hour. Or you can just tell them it's not applicable.
I just don't think it's applicable.
Okay. And I believe you also have the ones that they resubmitted, which didn't match up with the course titles and the course outlines from the last meeting, initiating devices, and overview of the life safety codes module
I have a request here for employee training, continuing education, initiating devices and fire alarm systems, 1 hour. And I think that is certainly reasonable. I don't know that we'll do it for employee training. They may have just checked the block there.
They do.
But I would think that for continuing education, that'd be very reasonable, and I would recommend approval there. Now, I have one other course, a 3-hour course, an overview of life safety skills, module 1.
That's one of the ones we had at the last meeting, and the course title and the outline they sent us didn't match. We approved module 2 of that in March.
One of the things they have requested, again, employee training, I think they just check that routinely. Continuing education, I don't have any problem. They have checked the categories burglar, fire, CCTV, and monitoring. I don't find it applicable to monitoring.
Well, since we only approved continuing ed and we don't even put a classification on it, I really think the little girl that fills those forms out, and I say little, I don't know what she looks like, but she's young.
Maybe we don't want to go there.
She's young because when I talked to her yesterday, she had sent me the wrong certificates from some locksmith. I really think she gets in a hurry and just checks boxes. So you kind of have to glean through what you get from Elite. But they're a pretty good company. They're based out of Austin, Texas. We don't have problems getting their certificates of completion for our licensees. We've been having a lot of trouble with LERC, one of our online providers. He sends us, Well, the courses are good, but they fax us the certificates every Sunday night. And if it doesn't go through, we don't get the certificates. And it doesn't seem like they ever mail the person that took one a certificate. They just send it to us. And then we've got people calling us going, well, I completed this course, you should have it, and we don't because either his fax machine was, we've been having a real hard time getting certificates from LERC. So, what did we decide about NFPA? Anything?
I don't think that this one applies. It's really talking about sprinkler installation. If anything, it's a long course. It would be helpful, but I don't think it would qualify for somebody's entire.
Is it an in-person NFPA course? It is.
I think
Isn't it
so.
one of their live courses?
Yeah, but it's specific to sprinklers, like how to install a sprinkler, where the sprinkler head should go. We wouldn't do, somebody licensed.
It'd be like a fire suppression company.
Right.
Yeah, which we don't do. All right. I had one other thing I tossed out there. It's this William C. Moore. I think he took the same course that, and I don't know that somebody has it. It's only a certificate and a little bit of training information. It's identical to what we looked at for Mr. Burns earlier. It's the electronic security technician entry level. They wanted us to consider that to meet the burglar alarm training. It was offered through one of those Virginia training academies that's only approved for Virginia applicants, and I had already told him I didn't think it was applicable. It was in the stack of stuff I handed out this morning. I'm just gonna tell him he has to submit an application like I told Mr. Gaston.
I think it's the
Burns or
thing to
whatever.
do.
So right now, we have a recommendation to approve the Tennessee Electronic Security Association West Tennessee Regional Lunch Meeting for April. Jade Learning, continuing education only for introduction to network security cameras. That was recommended for approval for 2 hours only. Elite CEU Alarm Level 1, 27 hours continuing ed, if they want to add that. Employee training and qualifying education for burglar only. Video surveillance systems and closed circuit television certification. It's a 15-hour course. It was submitted for qualifying education in CCTV, employee training, and if they want continuing ed, we can add that. That was recommended for approval. Foam and water sprinkler and spray systems, 2 hours of continuing ed. That was not recommended. Initiating devices, 1 hour of continuing education only was recommended. Overview of the life safety codes, module 1, it's a 3-hour course. Continuing education only was recommended. NFPA, installation of sprinkler systems, 21 hours is not applicable. And Mr. Moore, we're gonna tell him he has to have an app on file before we'll review it. So if that is and then all the CCTV courses that were submitted for continuing ed by Elite, we're gonna recommend approval for those of continuing ed only.
Right.
So we could have one motion and take care of all that.
Madam Chairman, I make a motion that we accept the courses that we've just listed for the times and applicability as we've just indicated. It was read into the record.
Okay.
And I'll make a second.
Okay, we have a motion and a second to accept the courses for their different applicability as read into the record. All in favor, voice by saying aye.
Aye.
All opposed? Cool. Anything else?
I don't have any other business. I do need to get you signed your travel and stuff before we depart.
Okay, we'll go ahead and adjourn the meeting until September then. Thank you. I was trying to get on my list.